affiliated to Guru Gobind Singh Indraprasth University, Delhi, and is approved by the All India Council for Technical Education, Ministry of HRD, Government of India for its management courses, and Bar Council of India for its law courses. The institute conducts programs of MBA, MBA International Business, BBA, BBA LLB, and BA LLB. The institute is accredited as A grade by NAC and assessed as category A+ by Joint Assessment Committee of Government of Delhi and Guru Gobind Singh Indraprasth University. The institute has been rated Grade A by Academic Audit Cell of Guru Gobind Singh Indraprasth University consecutively from the past 8 years. GIBS has also been rated number 2 by Times B School Survey in 2018, 19 and 21. Now, I would like to draw your attention towards our esteemed panel members, Dr. Bharati, Professor, National Law University, New Delhi, Mr. Nipun Kaushik, Director, Operation and Partnership, EcoRoots Foundation, Professor Dr. Kanwar D.P. Singh, Guru Gobind Singh Indraprasth University. So, I would first like to introduce our panelist, Dr. Bharati, who is currently working as Professor of Law at National Law University, Delhi. Earlier, she was teaching at Faculty of Law, Delhi University. Her areas of interest and specialization are environmental laws, human rights, humanitarian and refugee law, constitutional law, laws relating to women, alternative dispute resolution, etc. She is also the convener and member of several committees at National Law University, Delhi. She is a regular visiting faculty at Bureau of Parliamentary Studies and Training, Institute of Constitutional and Parliamentary Studies, and Haryana Institute of Public Administration. Various paper presentations have been conducted by her on different themes at several conferences, including SARC Law Bhutan and so on. She has been a part of Law Commission's panel on early childhood development and has completed research project commissioned by the Ministry of Women and Child Development relating to maintenance. She also joined the international environmental conferences held by National Green Tribunal in the past. She has chaired thematic session Challenges of Environmental Protection as part of the International Conference on Sustainable Development and World Economy held at India International Center, New Delhi. She has been key speaker at the 2nd and 3rd India Law Conclave on the theme of climate change and environmental laws, respectively. We are highly honored to have you amongst us, ma'am. And our next panelist is Mr. Nipun Kaushik, Director, Operation and Partnership, EcoRoots Foundation. Nipun Kaushik, a National Law University alumni, is a lawyer by profession and an environmentalist at heart, with a specific inclination on research and analytics. He has 10 years of working experience with NGOs, which provided him with a powerhouse of knowledge and understanding of operations and processes for an organization. Also complemented with direct experience of litigation, policy and legislation drafting, vetting of organizational documents, he is strongly committed to building institutional and sustainable processes and believes in teamwork. He is a skilled communicator and has worked on leadership roles like SOS Children's Villages of India and Oxfam India, other than supporting multiple grassroots organizations. He has been invited by various prestigious institutes of IIT Kharagpur, DNLU Jabalpur and NLU Delhi to interact with students on environmental conservation. He is currently serving as the Director, Operations and Partnership at EcoRoots Foundations and is responsible for building new associations and managing the current partnerships. We welcome you, sir. We also have with us Dr. Kanwar D.P. Singh. She is currently working as Professor at University School of Law and Legal Studies. She has been in teaching for the last 23 years. Her areas of interest and specialization are taxation and corporate law. She has contributed various articles and papers in different journals, national as well as international, like European Journal of Sustainable Development, Kurukshetra Law Journal, etc. She has also authored books on various themes like land laws, domestic laws, climate change, and so on. She has also handled administrative assignments as Director for Legal Aid. She has been actively engaged with various professional bodies like Indian Law Institute, Indian Society of International Law, Indian Institute of Public Administration, Institute of Constitution and Parliamentary Studies, Vice President of Asian Association of Law Professors. We welcome you, ma'am, and we are highly privileged with your presence here. Now I will request Dr. Vinay Mehri sir to present sapling to our esteemed guest, Dr. Bharti. Sir, please. Thank you, sir. Now I would also request Dr. Vinay Mehri to present sapling to our esteemed guest, Mr. Nipun Kaushik. I would again request Dr. Vinay Mehri to present sapling to our esteemed guest, Professor Dr. Kanwar D.P. Singh. Thank you, sir. Now we move ahead and begin with the session. I would like to introduce the moderator of this panel discussion, Dr. Neelam Singh, Associate Professor and Program Coordinator, GIBS.
Thank you so much, Dr. Kritika. First of all, I would like to welcome all our panelists. As you all know that today's theme is legal shifting from traditional to modern approach, boosting self-reliance in India, which is very relevant and important in the academic discourse. We know that India has a legal system and its roots in its history and its tradition. However, there is a demand to shift the modernization. Modernization, there are many factors which has driven this demand, like increasing the use of technology, need of efficient, effective system, access to justice, and we have seen many changes in this field. Like we have evident that there is the use of technology in the courtroom, the introduction of the ADR mechanism, and so on. So this is the theme of the topic, and before starting the discussion, I will open the forum for the opening remarks of the panel, and after that I will put some portion for the further discussion. So firstly, I would request Mr. Nipun to give the opening remarks.
Hello. Good morning, everybody. That was a little unfair to me with such an esteemed panel. I feel like already so nervous, but so I come from the NGO sector and less from the legal and more from the NGO sector. So I'll quickly speak about 2 or 3 things, which is one, fundraising or funding, which comes to the sector. Second, the compliance, which is changing from how it has changed in our in the sector. So from these 2 perspectives, and then moving on also to, as I said, how the educational institutions can actually contribute or can work towards that. So I'm saying like, because we're talking about traditional knowledge here and traditional systems here. So traditionally, India is a very Sanatani system, and comes from the Vedas and everything. And we had a very system of the system of giving was very clear. 25% for yourself, 25% for it goes to the religious activities, 25% goes as savings, and 25% is only for the other social activities that you can contribute towards. So that has always been the case. But fortunately or unfortunately, the corporate giving culture in India, particularly the NGOs, the philanthropy, or what we call CSR today, is fairly a new concept. So CSR was not known to many till about 20 years ago. Till I think about 2020, there were only 2-3 big Indian corporates which were doing CSR contribution. So and then the shift happened. So like Tatas have already been doing it for a very long time. I still remember Ratan Tata Trust, which was set up in 1950s, which was like we just got independent and they have already set up a trust. And when this 2% law came in 2013, Mr. Ratan Tata came up and said, we have been contributing around 42% of the company's wealth and at least 80% of my own wealth into philanthropy. So, but that's very rare. That's one in 100 kind of cases. Like Infosys was another big company, Indian company, which was actually doing CSR already. But then the shift happened. A big shift happened in the early 2000s when CSR became internationally as well as in India. It not only became institutional, it became compulsory as a law. The Companies Law 2013, it actually clearly said that 2% of the profits of the company needs to go to CSR, corporate social responsibility. Usme bhi people started finding ways. They started setting up their own corporations. They started setting up their own foundations and started doing. Like this was literally such a vehement, dichotomy to the whole statement of giving because people were cleaning their own campuses on CSR money. Something like that was happening. So I think that shift is still happening. For India to believe that the NGO sector is actually doing good work is a big shift. Then also from the sector's perspective, I think the skilling sector became too big. So moving on towards the self-reliant India, I think the Skill India movement which was started by the Congress government back in 2010 or so. But then when 2014 Modi ji came in, Modi ji took it to a different level. And today's skilling sector is actually one of the biggest sectors in India, even bigger than a lot of these corporations and industries. So so that shift has happened, and from a very skilling point of view itself, the sector has also moved, or India is moving more towards entrepreneurship. India is moving towards enterprising rather than being wanting to be employed. Today people are looking at how we can contribute, how we can be the sole contributors, and this has also changed inside the organizations. Earlier it was more of like a teamwork, people were team players. Now this whole work from home system has actually moved a lot of people from team players to individual contributors. So all that has been happening. So another point of view I quickly will speak about is compliance. So India had never, NGO sector was a lot of passion and people worked actually with so much of passion that no supervision was required. Sector and such players. But then I think the sector also became dirty and supervision was required, and then FCRA rules changed last year. 2021 saw a big shift in FCRA laws and a lot of big organizations having their FCRA cancelled. So imagine something like Oxfam, which was the third largest charity globally, got their FCRA cancelled in 2022. So that shift is also happening now. So you have to be on your toes with respect to the compliance and all that. So yeah, so I think India is moving towards a more stricter norms for all the sectors. I'm sure with there was a CSR 1 form which was introduced last year. So this is again Ministry of Corporate Affairs, which had almost nothing to do with the NGO sector.
is now having a direct supervision over NGO sector also, along with the corporates, because any money which is going into the CSR or being taken under CSR will have to be counted with the Ministry of Corporate Affairs. So I think that's a big shift which has been happening. That's what.
Thank you, Mr. Chairman. Our request Dr. Powell to please give the opening remarks.
Taking further from where Nipun left, that there has been a shift already in the corporate sector and the NGO sector. Two things I would like to point out. That okay, India is moving towards self-reliance. We have already taken the leap forward. We have amended our MSME Act. We are looking up at things that now we have to make India self-sufficient in the manufacturing sector as well. That is the main you can say the objective of the Atmanirbhar scheme or the Atmanirbhar slogan that has been given up by the government. And COVID has been an eye-opener for everybody. COVID made the problems that we face, the migration problems, the self-sufficiency that the people lost. But if you look at the data, like me being a taxation teacher, if you look at the data, India has done really well. It's not that our tax receipts have receded somewhere. We have increased our tax collections during the COVID period. We were able to give the paybacks to the individuals also. The corporate sector has also really performed very well. But what I would like to suggest here is, or like to take the conversation forward, what role the legal sector has to play in this shift that is happening. The earlier the traditional approach that we had towards corporates, towards individuals was increasing of the per capita income. पहले जो 40s 50s में we used to think was that what is growth, what is development. It was an increase in the per capita income. Now what we address is the poverty issue. We address the equality issue. We have to see that not only the per capita income has to increase, it has to percolate down to the grassroots level. That is the shift that is taking place. And education sector and the legal sector has a lot to contribute into it. See, if you have lawyers coordinating well with the public and the private sector, it gives a sense of sanctity, it gives a sense of firmness, it gives a sense of reliability. Like if you, I don't know, following up the whole Hindenburg report that came and the Adani shares losing money, agar corporate and law are working together, you will be at least assured that you have the rules and laws in place and it will not be a Satyam once again. That's what the legal sector has to shift from the traditional to the modern approach. We also have to, not to say that law or the lawyers or the legal sector has to come into place or has to come to function only when the fiasco has been taken place. कोई problem हो जाती है, कोई litigation point has come, then only the law will take its course. No, now the lawyers, the private sector, the PSUs, they have to work together and see that the people have a sense of fairness. People have a sense of firmness, people have a sense of stability, that the law is in its place. And the lawyers can be there to guide right from the inception. Like what Nipun spoke about FCRA and all these things. You need the lawyers, you need them to work with these sectors to guide them to make us self-reliant in a better way. And if you talk of legal education has to prepare the lawyers for these challenges. Now the new world, when COVID we used to talk about that there will be a new world order. The new system of working will come into place. But that has already come into place now. You would see that here. Now self-reliance is not only in the manufacturing sector, self-reliance has to be taken into every aspect of life. And for that, I feel the law schools, the legal sector and the corporate sector has to work together so that the fruits that they can reap are to the maximum. The development takes place to the core and it percolates down to the grassroots level.
Thank you, ma'am. As you both have said that modernization has impacted self-reliant India. For instance, we have seen that the modernization has impacted the investment and the economic growth. In the and we have to connect it with the legal field also so that the education institution can group the student in that manner that can help us in the economic sector as well as the CSR also. So thank you so much. I would request Dr. Bharti to please give your opening remarks.
Thank you so much. So I've had a very good, there's a good foundation being set by my two esteemed predecessors. So right now, I would just like to add here that when we're looking at the emerging scenario, it's truly a global society that we are looking at, and there's a convergence of the traditional and the modern. Undoubtedly, we have to have that kind of a situation where we are working towards kind of merging of these two, and India has to adapt to the emerging needs, to the kind of situations which is prevailing. And environment is a very important element. So, corporate sector, we saw the NGO sector, and so which means citizen participation has to be in all ways possible, in terms of information, in terms of participation active, and in terms of access to justice. So it does not end in a democratic system that by the casting of vote. The citizen has to be constantly involved, and I think there are so many ways to do it. And you can be involved in the law-making processes when certain draft bills are circulated for comments, for suggestions. There is the EIA process, environment, impact assessment process through public consultation, and there are various other means. And of course, access to justice, you have various forums, the apex court, the high courts, and the whole hierarchy of courts. So when you're looking at the emerging situation, all stakeholders have to contribute their might. And there are new themes that are emerging. You have the information technology sector, which is coming up in a very major manner. You have chat GPT, which is coming up with, there are all kinds of consequences and all kinds of problems associated with it. So we have to grapple with this kind of the situation which is emerging, and the higher educational institutions, especially the legal institutions, have a very important responsibility in this regard. So when we are looking at various institutions, the professionals, the law professionals that are going to emerge from here, they have to look at sustainability of various ecosystems. So sustainability means again we're trying to resolve conflicts, and we're trying to come to a very ideal or the most appropriate solution in terms of economics, the environmental, and the poverty alleviation. So these are the three objectives for any, I think, legal system. And it is in this context that when you're looking at rule of law, that has to be the basic pivot on which the entire, the superstructure rests. So I think these are the various issues which really we are faced with, and we have to come up with resolutions.
Thank you, ma'am. As we have seen the impact of modernization in various fields like economy, politics, like we are using the EVM machine, we are using the bond automation, we have seen the impact in the society, we are interacting with so many apps. So my question is, don't you think that India is known for its traditional values and traditional approach? And if we will shift towards the modernization, don't you think we will lose our recognition in the international level? If we will adopt the pure modern approach of modernization?
If I can answer your question, I don't think we will lose our place in the global scenario. I think we'll be appreciated that we have taken both of them together. We are adapting technology much better than the development. And we are not only adapting, we are taking everything together and then moving forward. That's my opinion.
You're right in saying that, ma'am. So the traditional values, we certainly bring them to the table, but adaptation to the global scenario is very, very, very important. So I'll just answer this with local, which is like local manufacturing to the international market, and that's how the whole MSME sector had grown in the last 5-10 years. It has grown tremendously, and that's local to global.
And whereas global to local is where we are talking about self-reliance, that we don't need to depend on the global scenario, and we need to be self-reliant in our own ways. So traditionally, our values are so important and they bring so much. So I do a lot of these spiritual practices also, and and that certainly comes with a lot of our traditional practices. But then I think we have to adapt a lot of it to the modern lifestyle and modern scenarios. We can't really go and have the the systems of grahast and brahmacharya, and also it's not possible at all. So and anyways Gita also says no. So Gita में भगवान ने बोला कि आप ये रूल्स हैं, ये नॉर्म्स रहेंगे, हमेशा मैं तो रहूंगा ही, लेकिन उस सिस्टम के हिसाब से, उस समय के हिसाब से you will have to adapt it, you will have to understand it according to the current scenario.
Thank you, sir. Catherine, would you like to add on something?
Yeah. So, Indian civilization is known for its, traditional values, and I think we are recognized the world over for these. And yes, it's a churning process at present time when there's this whole mishmash of the new and the old, right? So something better is likely to come out. It is hopefully to come out, and it's really up to us. It's up to all of us, each one of us individually, that how we participate in this process and how we, that the convergence or the kind of blend that is brought about is going to suit, our the best, to our ability and the circumstances. One thing I would say that the present kind of indices of, say development, they need to be re-looked at. So, when we talk about GDP or we talk about, the various economic indices purely, so they are not really the true indicator of growth or development. You have to, something akin or similar to, I'm not saying that is the kind of proper way or that is a possible way, but something like Bhutan, where you talk about national happiness, or you talk about other aspects of whether it's education, whether it's healthcare, whether it is general the mental well-being. So this is, I think these are also aspects which should be, and India can take the lead. Yeah. So we have always
to look at everything holistically, and look at what suits us the best.
Right.
And look at best.
So India has always taken up the leadership role, and we're aspiring to be, in the futuristic kind of situation, to be a world leader. So I think on this issue we can certainly, pave a new path, a new trajectory, of thought process, and yeah.
So you all think that modernization is important to make India self-reliant. So my other question is, what are the challenges facing India as it moves towards a modern legal system?
So the modern legal system, I think the change that we are seeing right now is too dynamic. The change which should have happened gradually is happening too quickly. And that is why, like ma'am just said, Dr. Mati just said, the whole mishmash, that's happening because I honestly think that, this whole change of in the legal system, in also the socially, how things are changing, how we are not talking about annual reports anymore.
So this is becoming one of the challenges.
Yes. So the quick change is certainly a challenge, I think. So, and also, we are not really looking at what she was just pointing out. We need to possibly change the indicators of growth or whatever, to also for each individual to understand. Because I keep talking about these particular things. CSR is one thing, corporate social responsibility, but we need to start looking at individual social responsibility. What are we as individuals contributing? Why? This is a small practice that I have started following. I opened this bottle in that conference hall and I carry it with me till I finish that. It's a simple step. So I think that is very important, where we start looking at our own selves. What are we contributing and how are we changing the world? and how are we making it towards a more, I think more than a self-reliant India, we need to move towards a sustainable, sustainable self-reliant India.
If we talk of what challenges the legal system is facing, I would like to point out that we have already shifted from CSR to LSR, that is the legal social responsibility. And I think the legal fraternity is doing a little too well in fulfilling the social responsibility. So we are already facing the challenges, overcoming them and moving forward.
Yeah, so the legal system has, it's really a barrage of so many issues that are confronting it, and one of them is of course technology. So we've seen during pandemic how hybrid or online systems were there, and how we are now, it's a hybrid system that we are actually having. So and how there were difficulties as teachers, as learners, which were there before us. So that's a very fundamental ICT systems, information technology systems. Apart from that, there are the software new ones that are evolving, which are on the issue of plagiarism and so on. We have to be alert and how to really tackle that issue. So technology is one area. And there is a lot of apprehension that it is going to dislocate jobs. There is a case coming up in US which is going to be, it's I think a robo which is really going to, put up, the whole issue is going to be taken up, through that artificial intelligence and not a human being. And so these are, and there are templates, right now which are there. For contract and so many others, so which the routine kind of law firm work which is there, that might come in for a lot of rehaul. So that is, technology is one point. The other, I think, is the human resource. So the human resources, how quickly they have to espy the opportunities, how quickly they will fill in the gaps, or how they respond to various situations, emerging situations. So intellectual property is another area, environment, human rights, these are all, but of course there are sub-themes to it, right? So there is a lot of work which is happening, say the law of the sea, marine ecology, so there are these kind of sub-themes that are there. So thematically there's a lot of expansion. There are lots of mechanisms through technology that are there. There are lots of institutional structures that are coming up. So at every level you find that there is collaboration, there is partnership, there is individualization. तो वो एक कहते हैं कि हर लेवल पे कुछ ना कुछ कंट्रास्ट भी हो रहा है और कुछ ना कुछ ब्लेंड भी हो रहा है.
So we have seen that there are many challenges while adopting the modern approach. So what do you think? What steps can be taken to ensure the legal system support the goal of the self-reliant India?
I think already covered किया
The legal system, I think legal system is already adapting and supporting. The appointment of lawyers like NGO is the most important thing that I could think of, that they're already working towards it. And the best that the law can do is to start supporting right from the inception. We should not wait for the disaster to happen. But we should be, पहले से if lawyers are involved in say the public policy making, in the implementation, they could foresee what is the pros and cons, and already steps might be taken.
And what kind of role the private sector can play in adopting the modern approach in the legal system?
The private sector, now there is no way that everything can be done by the government. There has to be public-private partnership. And private sector is already involved in it, and I think self-reliance has to come from them only. They have to work the most towards it, and we as law teachers, we as individuals, we should go forward and support.
Yeah, I'd just like to add here that the private sector plays a very, very expansive role is coming up, and it's always been there, and certainly public-private partnership is the way forward. But there has to be greater accountability of the private sector. That is something which has to be underlined, you know, because there was a very interesting CSE, there was an RTI which was put up by Center for Science and Environment, and the question was that whether between 1990 and 2022, how many corporates have really complied with various compensations that have been ordered through various courts, you know, whether it's the Supreme Court in the past or the NGT. And the RTA revealed something very strange, you know, the CPCB, the Central Pollution Control Board, just threw up its hand and said, we don't have any record. You know, and we don't have any record, and there has been no recovery, especially made from industrial giants, you know, like PepsiCo, like Coca-Cola, like even in the Indian context, the Ambani, Adani, whatsoever. So you find that that at that level, you know, where that the public kind of accountability is there, that is still lacking, and we have to go, some miles forward, many miles forward rather, before we can achieve some kind of.
To add to what you are saying, I have a scholar who is doing a PhD he is from the Income Tax Department, and he is doing a PhD on the charitable institutions, the exemptions that they get from the government. So he was trying to compare the last 10 years. The department itself has not maintained the record. Yeah. And if he being Commissioner of Income Tax cannot find out the record, what will we as teachers be able to do? It's accountability is a very important thing.
Most unfortunate part.
And we are not working towards it the way we should be working. If you do not have the details, what exemptions the government has given to the charitable institutions, how much, which year, they say we don't keep the recording that way. He being in the department is not able to get it out, and he is not able to convince people, or his IT people, कि तुम इस फॉर्म में हमें रिकॉर्ड बना दो. So it's the accountability that is mattering. If you are not doing research on these things, if you are not coming up with this kind of data, then the public will not come to know. Then you will not be able to even assess yourself. You have given them. We have to become accountable. We have not much options. We have to work for it.
Yes, you later said that it's a matter of accountability, but we all know that there is a very less number of people who feel that they are accountable towards the society and all. My question is, how we can make responsible the education institution, what we can fix up the moral responsibility of the education institution to make the responsible and accountable citizen.
So I'll quickly point out a problem that a program that I designed very recently. So this program is about SDG goals. All the 17 SDG goals, we take them to the schools, and we are currently doing a pilot with 3 schools in Delhi. So throughout the year, we will do these amazing workshops and with a particular set of children on different SDG goals. And the aim of that whole program is that the children are aware of those goals. Children would do something about them, that particular set of children, and then they will also take that back to their homes, and how the institution as a whole is contributing towards that, towards those 17 goals. So programs like those, I'm just giving one very vague example possibly, but it's a very interesting program, and schools are adopting to it very nicely. So what I'm saying is, as educational institutions, we have the power. I'll give you another program that we designed a couple of years ago. So we do a lot of eco-theaters. Now a lot of people ask us, why theater? When we are telling an environmental problem or an environmental discussion, why eco-theaters? So I say, what happens with eco-theater is that a group of 10-12 children who are involved directly are able to present the problem to such a bigger audience that they can understand it, they get sensitized about it. So schools, colleges, institutions are such an important place of mass communication that you can actually point out a problem, you can actually get people sensitized, and then these are the people who are going to go forward and become the corporate social responsibility leaders or the corporate leaders tomorrow if they are sensitive towards things. It can do wonders. Like I'll give you one more example, last example. स्वच्छ भारत अभियान भारत में बच्चों की वजह से सफल हुआ. हमारी गाड़ियों से कूड़ा बाहर फेंकना बंद हुआ क्योंकि बच्चों ने टोकना शुरू किया. ये जनरेशन तो बहुत खराब थी. I'm honestly saying like that. Ma'am wali generation, so they just didn't listen. My father would not listen. He would say, "केले का छिलका ही तो है, बाहर फेंका तो क्या हुआ?" But it is only बाहर फेंका जाता है. This is how they used to react. So if children could change that and bringing behavioral change in a country like India, where we hold our traditional values to our heart, it is not easy. So I think if that could happen because of children, and how did that happen? Because a lot of these Swachh Bharat Mission campaign workshops were being done in these schools throughout the country, and that changed. So,
But again, sir, you have defined the role and responsibility of the NGOs and the government who are running the Swachh Bharat Abhiyan. So my question was, how the education institution can
education institutions will have to come forward and start taking the lead in organizing, in being part of it. Unfortunately, what happens is the whole curriculum is so vast that teachers don't have time. When we say about the SDG goals, also SDG goal program, the principal is very interested, but the teachers will say exams भी करना है, copy भी check करना है, पढ़ाना भी है, क्या करें हमारे पास तो 6 classes है एक दिन के अंदर, कैसे करेंगे? तो and they are also rightly saying that. So, but I think I will say another program with DST, Department of Science and Technology. So they say that the program is how do you communicate science or creating scientific temperament amongst children through theatre. So and we do these workshops with the teachers. Now teachers say कि सब ठीक है ये सब ठीक है, लेकिन हम ultimately हमारे पास time ही नहीं है सब करने का. But then that's what I keep saying in these workshops also. Innovative ways of teaching. You need to get out of the class and start teaching like that, or inculcate all that into your teaching. Like 17 goals. It's just 17 goals. In a year, if we start talking about those goals, some change would happen at least. So I think the educational institutions have a very important role to play, from the management to the teachers to the students. So
I think Dr. Kaval can explain better as an academic.
When you were saying ma'am and last generation, reminded me of my daughter who always says the same thing. And she moves a little step forward. You're talking of environment, she talks of animals, pets, giving them food, doing this, taking care of them. And I really feel that educational institutions have to become forward and we have to look beyond our curriculum. And then only we can play a better role. If we are still bound in this rut of the things कि हमें तो class ही लेंगे और हमें तो syllabus ही पढ़ाना है, I really you could make it very interactive also. Like interactive in the sense that we are still into assignments and checking and marks. उसके beyond हम सोचते ही नहीं हैं. And if you want to think also, there will be 10 people pushing us backward कि नहीं ये नहीं करना है, ये इससे तो कुछ होगा नहीं. But if you go and look at the other countries, like my daughter herself, she teaches and what she does is she'll give a Snapchat. इधर एक story बनानी है जो Snapchat पे डलेगी. You are transported back to time. You are doing this for the country, and that is the assignment. जो assignment हमें महीना भर बच्चों को कह के नहीं मिलते, Snapchat या Twitter वाला assignment हमें एक दिन में मिल जाते हैं. One of my teachers in my university teaches social economic offenses. So what she did is she made a list of Netflix movies and said कौन सी movie कौन सी social problem को tackle करती है और उसमें लॉ क्या है. ये उसने professional skill development activity थी. जो हम पीछे दौड़ते रहते हैं वो एक दिन में सब आ गया. It was such an interactive session. So we as teachers also have to do an out of box thinking. I fully understand कि पढ़ाना भी है, कोर्स भी खत्म करना है, ये भी करना है, कैसे करें. But if you start thinking towards it, वो हो जाता है. And I can really tell you with my experience. पहले मुझे लगता था when my daughter used to insist कि मम्मी हमें dog रखना है, pet रखना है. मुझे लगता था कि यहाँ आपका काम तो हो नहीं रहा, definitely you want to get another pet. This is too difficult a position. But once, believe me, वो कहती थी मैं साफ को नहीं रखना था, stay dogs के लिए बाहर पानी रख दो, खाने को रख दो. When I started doing this, automatically time निकल आता है. We are able to move forward. And when one teacher did it and others are so appreciative of it, it not only encourages that teacher, it encourages other teachers also to perform in that manner. Now, a subject like socio-economic offences, अगर हम link करें Netflix से, तो see undergrads कितने interested हो जाएंगे. So that is only way we can address these challenges. and there is no option. We as teachers have to do it, the students have to come forward, and depends upon us how interesting we make it for them. अगर कोई बार-बार वही assignment, वही लिख के लाना, वही 4 पेज की report, nobody wants to do it, and nobody is interested in taking it also. And after hearing such innovative things, कि अपने words Twitter पे लिख के मुझे भेजना, Twitter Tuesday, Snap Saturday, making things like this, you also feel a little energetic. You also want to do something more. And I fully agree with him. Swachh Bharat Abhiyan वो आपकी बच्चों की वजह से सक्सेस हो गया. Definitely, they are the ones who
set up contours of different subject themes and the kind of syllabus that is there, and to ensure that there is both the skill and the social relevance of the component. So, I would say that, for instance, legal aid, which we, where every institution now is expected to discharge, and in fact, it's a mandatory requirement of the Bar Council of India. So we have a certain credit, paper which is exclusively meant for legal aid. Perhaps it's time to rethink and to associate this component with every subject. So it's, when you talk about family law, you talk about corporate law, you talk about different subjects, it can be, aligned with it in some manner. So, and of course there are various, because I'm associated with clinical legal education as, clinic 3 and 4, which is legal aid as well as advocacy skills. So, there can be many innovative ways that can be done. Moreover, I would say the administrators, the side, like in NLU Delhi, we recently had a very important addition that, there was a lopsided kind of entry of students, that there were more boys and less girls. So kind of reservation was introduced for the girls in order to keep that balance, a little better, and it has played dividends, and it has resulted in a more even kind of situation that is there. So, so when you're looking at absorption of faculty or administrative people, so you can keep in mind, different aspects, and I certainly agree that SDG goals, the 17 SDG interrelated, interdependent goals, they give us a blueprint as to how to proceed. And even if we keep it just, aligned to this basic structure, it would be enough. It would be enough of material with which to progress. So I think there can be so many ways in which an institution can, look at these challenges and can have ways and means to.
And to add to it, I think the primary requirement is changing the individual mindset.
Yes.
If we change our mindset a little, become a little more embracing, become a little more accepting, I think much of the task will be done. If we just leave our stiffness and we think कि नहीं ये हो जाएगा, या अगर नहीं भी हुआ तो at least listen to what the younger generation has to say. It would be more better.
And one thing more, because it's such a topic, which can, like a teacher, typical, we can go on speaking. But in today's, kind of information explosion which is there, and every student is ahead in terms of so much of information, the teacher has to keep one step ahead. And that keeping one step ahead is proving to be difficult. So it is being envisioned that, soon we might have we may not have classrooms, we may not have formal classrooms where the teacher, what kind of role the teacher might have. So that value addition that the teacher provides to a class, to a subject, that critical thinking ability, that is something which is relevant, that has to be brought in by every teacher wherever we are placed. So it's not the routine and the mundane and just teaching, the course. You have to work yourself, in a manner where you are, incorporating these various skills yourself, so that you are able to impart them eventually to your students.
Thank you. I think with this discussion, audience have a lot of questions to ask. So I am opening the forum to ask the question. Audience are free to ask the question.
Thank you very much. I must thank the esteemed panel. It's such an animated discussion that we had. I belong to the private sector, and my question is, I want to understand, and I feel that CSR is still considered in the realm of philanthropy. To my mind, it should be in the realm of investing. Let me just complete my question. Why I am saying it? Because it's a social and environmental concern, and it's an investment. It's not just a philanthropy. Number one. Number two, if we look at our law, yes, we have come at far, but we have a long way to go because it's not in line with the United Nations definition of corporate social responsibility, which clearly says it is to integrate social and environmental concern to the business operations and interactions with the stakeholders. Nowhere it says that it has to be 2% of the profits. Right. My point is, we have to move forward by putting it as an investment and maybe put it as a 0.5% of the net sales in the P&L, rather than making it as a 2% of the profits, which means it's like saying, the day I become Mark Zuckerberg, I'll be philanthropic. But today I'm earning so less, I can't. So I think I would like a panel to wait on this. Policymakers, I think, should think about it. I think we have to move a step forward.
So I'll just answer. So quickly. So basically, sir, from a very investment point of view, what you pointed out. So I also keep saying this to the corporates that don't look at it as philanthropy, and the corporates who just write a check and leave it for us to do the job, we also become a little slacky. We, but the corporates will actually get involved. So, but now corporates are getting employee engagement programs very strongly. Number two, they are also looking at it from a point of view of marketing. Like CSR is usually now being within marketing, branding, communications. So I think that way it is an investment for the company. Also, from an investment point of view, it started doing a lot of, it happened, but it started doing a lot of backyard philanthropy. So everybody wanted to do philanthropy, but where their factories were located, where their companies were located. So the actual need which is there in the areas where they do not have factories or industries, like possibly Bihar or possibly some parts of UP, the thing was actually not reaching there at that level. So I think it is a good mix. And what you say about the 2%, again I would say that it is just setting a mark for the ones who can certainly afford. But it certainly doesn't say that if you are not reaching that mark, you can't do it. And we must, that is why we are talking so much about individual responsibility. I think people should rise up to this opportunity that the country is providing today. And philanthropy, like I worked with Oxfam, and Nisha, who was heading Oxfam at that point in time, she used to always say that do not go to a corporate with a begging bowl. Because we are not, it is not our requirement. It is, they want to do this. They have to do it. We are just providing them with an opportunity to do it the right way. So I think it is more to do with a very, like what also was being discussed as an individual responsibility. I think we need to come forward. It is now time to shove it up to somebody who can do it or cannot do it. I think the corporates also need to take this responsibility. Also, individually, we need to take this responsibility more.
Can I just, I just add something. Like, what happens when multinationals come to the country? They spend so much on marketing, on the brand image, which is important. I'm not saying no to that. But what happens is, in the process, they stay in losses for 5 years, for 10 years, having tons of money. But because the law says is 2% of profits, they still wait for the profit to come in and then engage in CSR. So if we put it actually as a 0.5% of the net sales as a law, then you even if you are a multinational, you come to the country, you still do corporate social responsibility.
I think it's a good suggestion.
I would like to add something. So I agree with your suggestion that we should be doing philanthropy right from the beginning. Somehow it does not suit my mind that it has to be an investment. Because if it is an investment, you will look forward to a return on investment. और society में कुछ invest करके जरूरी नहीं कि आपको return मिले. That's the whole point. Now to come to the putting a norm of 2%. If you say 0.5 of this and start, I feel philanthropy is for those, philanthropy is a word that could be used for people who are willing to do. And CSR is for the people whom we are forced to do. जो नहीं करता. You are supposed to give something back to the society. And if all corporates would have been doing like Tata, I think there would have been no need for the law. There would have been no need. And putting it as an investment is making it more to look into profits, not giving back to the society. आप अगर एक चैरिटी दे देते हैं ना तो आपको पता नहीं करते कि इसमें कोई रिटर्न कितनी मिलेगा. बट अगर आप इन्वेस्टमेंट देंगे तो जो बिजनेस माइंड है they will start thinking that now I have given this as CSR, what return I should get it on. But the step you said that you can make it 0.5% and they will try from the beginning, making charity a law, I don't think would be very successful. That's my thought of it. कि हाँ हो सकता है people the corporate they are into losses for the coming 5 years and then they will do it and they start making profit. So losses and profit, you in the private sector would know it better than me कि window dressing of accounts happens everywhere. But कोई तो point आएगा जब आपको window dressing रोकनी पड़ेगी. आप तब तो हमें 2% दोगे, society को back दोगे. But अगर इसे बिल्कुल pure investment if we make it, I think it would be making it more corporate. That's my take on it.
So, I tend to agree with Professor Kaval that making that whole venture, in that sense as part of investment might have its, it might create more problems. But certainly there is a need to relook, at this whole idea of 2%. Because we are seeing that as there is a lot of window dressing about even this minimal nominal 2%. Yes. And somewhat we are not getting that kind of returns, which are due. Because I see the force of your state partake of their responsibility. It's not just mere charity. That point is a very, very, that basic, proposition cannot be, I think we cannot challenge it. It has to be taken up as in terms of investment in that sense, that they are not doing any great favor. They are using resources and they are exploiting and they are, whether it's human resources or natural resources, and there is a need to, in some measure, repay, whatever can be done. So, I'm not sure as to what is the right way out of this imbroglio, but certainly there is a need to re-look at it.
And just before this panel discussion, me and Nikhil were discussing about Coca-Cola. Like they giving us funds. And he said, yes, they are washing away the sins. But chalo, washing away the sins, when they give us the money, what's so bad in it? I was asking him that the whole Coca-Cola thing in Atlanta and US in which they have their formula and so-called museum that they have made a center for human rights. And in that place, they have very proudly displayed that why they walked out of India was because of some rumor issue. I understand कि मीडिया कुछ proactive हो गया था या मीडिया का आम चल रहा होगा या okay but they did not like it. But that was not right. We cannot predict what is the right way, but yes, we could make a law a little more flexible and try out different ways also. That would be a better way.
And certainly for the multinationals that are operating, there is no law to bind them right now. Even despite Bhopal gas disaster, I think internationally we have not proceeded forward, So internationally or even nationally, we don't have, we work within the penal code system, or we have Indian penal code, or we have a tort law, or you have those basics, which is the basic legal framework. We don't have anything specific to multinationals, operating the country. So we need to evolve the law also, to make it more updated, to take into account the various possibilities and to avoid any catastrophic situation in the future.
Any another who wants to ask the question?
Well, I would ask a question. We have been discussing about and I say that modern to how we are moving to a traditions. As a common man, I am not bothered about what the corporate is doing or what is taking place. My problem is that as an individual, when I am approaching the court, those days it takes a time, 2 years, 3 years to settle the cases. Now, what is happening when there is a blockchain, is there artificial intelligence? So many people talk about a lot of technological change. Has that any impact in Indian law related to technology? Are they able to, what do you say that, solve the cases in just 1 day, 2 day, 3 day like this? Is there any system has been changed? This is what I would like to discuss with the panel right now.
So there have been a few changes that have come up, especially during the time of pandemic. There were virtual hearings and hybrid hearings, and that has expedited to some extent. That has brought, the litigants actually more forcefully or more immediately to the courtrooms. In that sense, so technically, procedurally, we have tried to, I think, come up, in terms of technology. But yes, in terms of the time span of cases, we have not been able to resolve so far, because the affliction of the system is too deep. It is, in terms of vacancies or in terms of the judge population ratio. I mean, it's considering the diversity and the population size, it's admirable, that we are having such a, the rule of law prevails and we are not, becoming a chaotic society. So it's hats off to the people and of course to the judicial system, which has maintained its credibility despite all odds. But of course, there's a long way to go in terms of how to contend with these issues, especially the pendency of cases. And I think the basic way out is the ADR mechanisms. Alternate dispute resolution mechanisms, in US perhaps 90% and more cases are resolved through these. So only constitutional law questions and criminal law jurisdiction, that is approached through various courts. But otherwise, most of the other issues, they are resolved in this manner. So we have to adopt it in a very, very strong manner. So when there's a call for mediation, arbitration, the problem in India is everything kind of deteriorates towards litigation. So even the arbitration proceedings, they become so formalized or they become so costly, or they take time and so on. And so it is not bringing out that kind of resolution efforts. So mediation is now the new kind of that slogan, and which is perhaps if we take it up in the right way, then it can give us some more rewards.
So I was in the law school almost 12 years ago. And ADR was still being spoken as one of the, and this is what, unfortunately, we as a system hasn't really moved. So I remember in 2005, I went for this William C. This food court, and at that time, we were talking about as arbitration as the next big thing, and mediation as the key word to solving the pendency of cases. Unfortunately, we haven't moved anywhere from there. We are still when you were just talking, I just remembered my law school days, and then. So one thing I think which has really changed because of what you pointed out, the technology and the courts moving to videos, on live streaming of these videos. At least what is happening because of that is, and this is, I was sitting with sitting in the LG's office with one of these very senior secretary students. So he was saying, "आप कम से कम फाइलें नहीं दिखेंगी कोर्ट में." The accountability of the judiciary also will change to a different level. Earlier, I am not saying judges are very, very, a lot of them are not companies at all, but a lot of them are. They should just throw files, they should just throw, they should use foul language and whatnot. At least that would not happen.
So when we have gone digitally, why there is a mistake that so many paperwork is carrying on in the legal system?
Sir.
How can we come out of that things? Why can we take an action immediately?
It's not so easy to sit at the discussions and see that the system works. System takes its time to work. And it's not the, why is the system there? Going away with the system may have far more protection than we sitting here can realize. Not to say, results are not visible, but not to say कि कुछ हो नहीं रहा. Things are happening and might be tomorrow you don't require these things. But the change is the only constant, but it has to come slowly. You just cannot do it in a day. That's what
we just spoke also. Now, as one of the challenges is that
Let me tell you one thing. Suppose if the common person is going for a succession certificate, okay, those days it takes let's say 2 years, 1 year like that. Because I have gone through that system. Okay. Now is the same thing is happening now? When you say that the technology has improved, why the technology can't be applied in let's say that laws?
It is being applied, but not at the level we want it to happen.
Yes.
That's it.
And another challenge is that we need to check how many people are very well versed with the technology. The number of the people.
Yes.
also the diversity of what the legal system is catering to.
And we in Delhi can sit and say कि इसमें ये apply हो जाए. It cannot apply everywhere. So you can't do this कि Delhi में ये system चल रहा है. कहीं तो कहीं constants maintain करनी पड़ेगी ना. And see in Delhi also, how many people are aware कि हाँ live proceeding हो रही है. How many people will be willing to do it. And how do you not know कि उसका aftermath क्या हो. So we have to take very cautious steps. If you talk about succession certificate only, you have to be very cautious in all this. You just can't. And see, we might be very well versed. Not necessarily पूरी दिल्ली well versed है ना. Not necessarily. It might create more problem. But not to say change नहीं होगा. Change is happening, though at a slower pace.
I would say here that awareness programs, especially in the institutions, the education institutions take the lead. They play a very major role. So there was a lot of hesitancy, when the first kind of directions came for mediation and so on. There was many advocates were not receptive to it, but now they have now amalgamated it, as part of their professional ethics, that how they move forward. So I think digitally also, and the kind of pros and cons that are there, the need to adapt ourselves quickly and in a quicker pace, not so quickly, but at a quicker pace, with all these challenges, that is important. So that element of the individual, wherever we are placed, हम कहीं पे भी होते हैं, कई बार ये होता है ना, जब हमारा काम नहीं हो रहा है तो भी just corruption का issue आ जाता है, you just extend some kind of, because I face the same problem what you are mentioning, and that's the easy way out, you are offered okay, you with 5,000 or something, you can get a quicker succession certificate. So there, our own resolves or maybe our circumstances, they would prevail. That कितना आपको ज़रूरत है या to what extent you can move. But there are systemic challenges. It is so deep rooted from such a long time. So I think that is taking time, to change. And I think, if we set our hearts to it, then I'm sure, we can really do wonders, because Indian people, they are resilient by nature. They are very strong in that sense, morally, ethically. We have eclipsed ourselves, in over a period of time, through our enslavement over the past so many, hundreds of years. But I think it is time for us to come in our own and, and take up all these issues and resolve them.
Okay, thank you. We will take last one question. Audience? Okay, thank you so much, panelists. You all have covered and discussed so many areas, whether it's role of NGOs, CSR responsibility of an individual, multinational companies, or the role of
Panelists for devoting their precious time to this fruitful discussion. Now, I would request Dr. Ram Narayan sir to present memento to our guest, Professor Dr. Bharati. Sir, please. to our guest, Mr. Nipun Kaushik. Ma'am, please. I would request Dr. Vinay Mehta, sir, to present memento to our guest, Professor Dr. Kanwar Singh. Thank you, sir. It will not be wrong if I say that the event of this nature would not have been possible without the cooperation and contribution of all the team members of GIBS. With great pleasure, I would like to express my gratitude towards our worthy panelists, Dr. Bharti, Mr. Nipun Kaushik, Professor Dr. Kanwar Singh, and Professor Dr. Vinay Mehta for their support and guidance. I also extend my sincere thanks to our Honorable Vice Chairman Sir, Shri Anirudh Jindal, for his constant support, and very special thanks to our academic dean, Ms. Prachi Jindal ma'am, for her guidance, her encouragement and constant support. Today's session was really enlightening. We look forward to your visit again, and we hope you had a pleasant session with us. I would like to invite all the participants for the tea break, and after that we will be starting our next session. Thank you, everyone.
Of the country has been through the years. So let's have a look as well in the Ministry of Commerce and Industry has released a people session for startups, which was very important. It's 80%. So that means that patent applications will have this concession available, including for small businesses. Very, very important. And the reduction in the time of patent examination is another aspect absolutely important for having innovation and new inventors getting into commerce and exploring their inventions. So on those links that I just put aside, you can see some of this data that I'm just talking about. But let's talk about this in India. Should we do this in India? Of course, of course. If you look at the global index 2022, and I'm going to call you for page 18. So if you can follow the link that we have over there. On page 18, just going to go back there. Page 18. If everybody is with me, is that you know? So on page 18 of this marvelous global index, so you can see that India is here on the first country in Central and Southern Asia. I don't know if you can see this through my screen or you can see with your aid. Please let me know. Are you guys following on this? Or should I share screen? Just quick note here. That those indicators, they show actually that India has been doing so far very, very well in domestic markets as well. And this is very important for innovation again. If you don't have domestic inventors, but you have only international applications coming through, you will have what we call the import of inventions, but not exactly creativity in the whole territory. So this is very, very novel, just to mention. Another area that I would like to make a comment so far today is where India is leading, which areas they are very important. In this global index you can see as well. You have the ICT services, everybody knows, venture capital coming to the country, finance for startups, runways that they have been very well and successful, especially in Australia, that we have a special treaty. I don't know if you guys have been aware, but we have a special treaty with Australia and India for bringing in postgraduates, especially science and engineering. Labor productivity, domestic industry diversification is what it is. So with this, we have to think, okay, so what is missing? What is missing? It's nothing missing that. I think, we need to be more proactive and think that in the southern hemisphere, we have investors and we have enough innovation to move on in the future. And I think in the legal aspects, I would really trace back to the area that I did research, which is plants and not food. I'm pretty sure in India we have been looking into taxonomy, even my colleague and I, and we have to identify new plants, because from new plants you have pharmaceutical, new products, have new medications. Just again, you're going to see that the new COVID and it is actually administered by drops instead of the needle that is so unpleasant. At least to me, I don't like needles on this one. So I just want to leave you with this reflection of what is missing. I don't think that much is missing. I think there is quite a future for the country. What we have to do is just to put the resources in the right place. And that requires management, that requires education, that requires academic work as well. And I'm pretty sure this can be achieved in the next 5 years. I would say 5 years. With this, I just think about what can I provide more to have a positive impact on this keynote address. And I think, go back again to the three elements that I was talking about. You have to think that a country with youth, tenacity, and creativity can go miles. And I'm pretty sure that India now that is in the top one innovation economy, in that lower middle income will just increase. Will just be something that they're going to see that it's going to go up and more successful. So this is outreach. Thank you for your time. Thank you for your attention. And I'm open to questions as well. Thank you very much. And I hope you enjoyed it. Very brief, but I hope with interesting content for you to think about it. Thank you.
Thank you so much, ma'am. Thank you, ma'am, for your address. It was really great to hear you, and thank you for joining us and sharing your knowledge and sharing your experience with us. So we are highly honored to have you with us today, and we hope to associate with you for future events of ours as well. Thank you so much again. Thank you.
So the session chair for law track is the session chair of the session chair of our law track is Shri Abhinav K. Mishra, founder and CEO, My Lawman. Sir is currently AI Policy Fellow at CEI DP Washington and Doctoral Fellow in Artificial Intelligence and Law from the United Nations Mandated University for Peace, Costa Rica. He is an enthusiast, professor and advocate of IP, media and cyber laws. Sir is also the partner of LexPlex Legal Tech Consultancy, Head Research and Innovation Division, My Lawman. He is adjunct professor IP and Media Laws, Lloyd Law College, and guest lecturer at Indian Law Institute, New Delhi. He has been research fellow IIT Tokyo on a project of Japan Patent Office to work on blockchain recipients and IP law, fellow for First Hainan International Film Festival, China, and ex-professor at Sharda University and Maharishi University of Information Technology, Noida. Sir is a member of International Sociological Society, Indian Society of International Law, Society of Legal Scholars, London, and GAJE. Sir has received fundings for GAJE Scholarship for Conference and Asian Law Institute Annual Conference. Sir has completed his LLB from Banaras Hindu University and LLM from Indian Law Institute, New Delhi. He obtained his LLM specialization in IP laws and human rights and did his dissertation on human rights in critical information infrastructure protection. His research areas are digital IP law and cyber law and forensics, human rights and technology, jurisprudence and legal theory in context, legal aid and access to justice. We are highly honored to have you amongst us today, sir. I request Dr. Neelam Singh to welcome our guest to this happening. Now I request Sri Abhinav K. Mishra to enlighten us with his words. Please, sir.
Thank you for this long introduction and to this august gathering of knowledge creators, disseminators, inquisitive minds, where we have gathered here to this international business school for two-day international conference on global information and business strategies. So I welcome you all as the knowledge creators, disseminators, the inquisitive minds sitting here for the sharing of the knowledge creation, ideas, concepts, thoughts. I welcome you all for this thought-provoking, knowledge-creating session of this warm introduction done by GIBS. I congratulate them for organizing this international conference and calling all of us here so that we could do some knowledge creation. I thank Dr. Anna, the fellow panel member of this track, keynote speaker of this track for advocating and calling Southern Hemisphere South voices from the international sphere for the knowledge economy, business information gathering, and information creation, which actually we have been tasked here by the objective of this international conference. And therefore, I would call upon you guys, I won't be using ladies and gentlemen, not making myself guilty of gender biased approach. I would call upon friends, colleagues, seniors, office bearer of the GIBS International Business School, the organizers and organizing team members of this conference, and fellow panel members, especially Dr. Anna, Dr. Needham, and all of you presenters with your inquisitive mindset. So I welcome you all to this conference, to this session. And before I begin, a short deliberation on the topic which is very pertinent, that is global information and business strategies in the times of the new technologies, especially artificial intelligence. I must point out that what I said yesterday. When I saw this global information and business strategy conference, I took out one exercise, the practical exercise, finding out that how information gathering, the information technology, the new technologies, artificial intelligence, blockchain, IoT, etc. and all, are trying to affect, or rather I should say, disrupt the global businesses. You might have heard of the ChatGPT. How many of you heard of ChatGPT? Okay, heard. Quite a few hands, but ChatGPT is rather a very medial adoption of the conversationalist artificial intelligence. By this sentence, I mean that ChatGPT uses the capability of the artificial intelligence into the textual conversation format, not using any other specific additional technologies, but just giving you the answers to the questions which you will ask in a chat. But despite that, it has been well celebrated throughout the sectors, either the business, law, social sciences, even accounting and sciences. By various stakeholders have been using ChatGPT, and I can just take you one example, and you can imagine that what is the way of ChatGPT is trying to do. The cost of ChatGPT, the running of the servers of the ChatGPT is running in around $500,000 per month. The $500,000 per month running in the processing power used by ChatGPT only for the conversational AI. It is not doing any image processing, video processing, or any other involvement of other such information processing which takes enormous amount of processing power. It's just using the information contained there in 2021 and giving you back the answers to the questions being asked. Even for that purpose, within few days, it received millions of the sign-ups. Millions of the people started using ChatGPT, and that took them $500,000 of the monthly expenses at the first month when the ChatGPT was launched to the public in the world. Now, my practical exercise. So, I try to put these wordings into the ChatGPT and try to find out certain ideas. What could be the opening ideas for this conference? What could be the thoughts which could be shared with you guys in academic setting, giving you some more which you can get me, because as a student, as a knowledge creator, I always look for giving knowledge, and I thought that it would be pertinent to give you something more. That more I tried to take from artificial intelligence, and it gave me an extraordinary answer. The answer comprising of the summaries which any fine gentleman of business strategy would have given. But at the same time, it was lacking something. What it was lacking? It was lacking the human touch. The human touch, if we see the anecdotes being shared, experiences being included, the way the information is being presented, it was very stereotypical. And that's why I'm not agreeing those things which the ChatGPT just presented. That's why I'm trying to speak out to you, Avi, right now. I also wrote, my exercise was finding out the ChatGPT's answer. Then I wrote my own while I was coming in the car, then I tried to write in few minutes. And then I'm trying to speak extempore there. And I'm trying to make a comparison in my own mind. I'll try to read out a few wordings which I wrote in the car as well. So what ChatGPT gave me, that was quite state version of the information, although concise and extraordinarily detailed. However, at the same point, it lacked human touch, it lacked the human experience, it lacked the intelligence and the way, the creativity actually, not the intelligence but the creativity of the human creativity by which a human delivers the same information in a rather different way, by which you guys would be taking the knowledge up in the mind and then recreating the same. And lastly, that while that information was given, the human anecdotal approach, human biased approach, although there has been another discussion on the human element in the biased approach of the artificial intelligence, but still, not going to that discussion and then coming back to this point, that while giving one concise version, when we speak and take out one of our topic, we have our own biased approach. Sorry for using the word biased. Rather, I want to say that one-sided approach. But that one-sided or biased approach sometimes becomes the foundation of another research. Not accepting the same would be your idea. Contending my thought process, contending my concept, contending my idea and approach. That may be totally one-sided, that may be wrongly one-sided, but at the same time, then the idea of the researcher, knowledge creator and disseminator comes into the picture. When you try to deviate from that topic, when you try to contend that concept, one-sided approach created by one researcher. And here comes the idea of this kind of knowledge gathering, this kind of people's gathering where we could have that kind of approach, listening to every distinctive approaches, working upon the same either in furtherance, for or against. And that's what I thought is the objective of this international conference. And I call on you, all fellows, colleagues, panel members, discussants, presenters, to build upon the prior art knowledge as well as add upon something, so that the objective of this conference could be fulfilled and be successful. If we talk about something more about the global information and business strategies, the use of the business strategies in the form of the new technologies, artificial intelligence and all, we can see that many examples could be seen. The business disruptions done by new technologies, particularly artificial intelligence, in the field of complex data sets, gathering, collection and analysis, big data analysis, image processing, video processing. You might have seen the example of the fake videos and revenge porn being one of the primary issues right now to be discussed in the criminal law context. So these kind of examples you may see that are using the new ways, new strategies to bring out the new startups and the businesses. Ideas you will find out that sometimes have been implemented either in a novel way using the new technologies, and for the others where the businesses are now today heavily dependent on the information. Either they are the information-based businesses or they are taking help of the information communication-based systems in a new way, using the old business in a new format, using the new information need. For example, Zomato, Ola, Uber, Oyo, etc. They have the same old business, but using the new given information technology needs. Amazon, Flipkart, etc. These all companies are using the artificial intelligence, machine learning systems. Way back, I hope, when it started was around 2003-2005. Information technology, information communication technology. That how and what kind of use is being done of these technologies. So one very final simple example I could give that very recently CCI have given the penalty to Google for using not good market practices using the Android operating system. Today I read the news that Google is now trying to change its whole strategy, the full sweep of the marketing strategy of Android and allied systems. So you can see, as Indian Competition Commission penalized Google while doing marking certain strategy as not market friendly. They tried to change the whole strategy. However, the product would remain same. And it is pertinent to note that Google bought this Android operating project for quite a few billion dollars. So $1 billion have been invested in operating system, that too being open source. You would be knowing that recently even ROS have been launched by IIT Madras, which comes from the AOSP, Android Open Source Project. And you see that since it is an open source project, anyone can recreate, remodify or remix the Android operating system. But despite that, Google invested billions of dollars. Of course, they wanted something back. They wanted the profit back. But earlier their strategy was to make it exclusive for their Google services so that their Google services could grow and they could grow in number of profits. At the same time, they were trying to even create the market where they could charge people out of that. CCI founding those strategy, the old strategy, the money-making strategy of the Google, and then penalizing the same. They now need to recreate their strategy. But do you really think that by blocking up these kind of strategy by CCI, the Google will lead the Android project? No. It happened a few months back in Egypt, and now Google have reconsidered certain other strategies to bring out and stand in the market against. Android will remain with the Google. Those $1 billion, all those have been repaid, but Google will try to re-monetize the same Android project by finding out certain other business strategies. For the same, it could also be said that for the business where businesses have been dependent on the information sharing, or information communication IT based systems. They have become dependent on data. The data being fuel of today and tomorrow. They must seek their practices in sync with the protection of data. It's not same as the data protection. I'm not talking about the data protection right now. I'm saying that the protection of data, to which we may call data rights. If the data rights, data protection, not in the sense of the data protection laws, but protection of data, the ownership of data could be addressed and strategized by the businesses. IP laws, intellectual property laws, copyright, patents, design, trademarks could be used to sustain the businesses for the longer period. The famous example of Coca-Cola could be seen. When Coca-Cola entered the Indian market, Indian government asked them to disclose their formula. They did not. They adopted the trade secret approach. They did not go for the food patenting methods. Their business would not have been here. You see the example of Maggi, Nestle, instant noodle. Now we colloquially call it Maggi. Whereas this instant noodle was patented by another company, Nissin. That powder milk powder, it was patented by one American company. But after the expiry of the term, we see that they lost their economic interest and right into the same, and therefore it came back. However, they tried what I should call that because in Maggi, in instant noodles, they actually could not get back for the 20 years to the time period. That was the amount which they invested for their research. But still, the strategy in Coca-Cola would be one of the examples. That's how IP laws, IPRs should be used. The protection of data right or data ownership should be addressed. The question for researchers of law is also there, that how Indian law is going to address that, since there is no one particular law related to the data right or the protection of data or data ownership in India. We must address that. And therefore, the job of you researchers, knowledge creators, comes into the picture where you can address those issues and can write something on that. And lastly, we see the different kind of strategies on what patent and when to use. As I took one example of the Coca-Cola as well as the trade secrets, confidential information and the other information used could also be used as one of the legal strategies for protecting and sustaining the business. Not speaking much onto this, I would like to conclude here by giving you this open-ended thoughts. What government particularly is doing for improving upon the business, startups, MSMEs, what kind of protections have been provided to them by the government? There are many startup incubation strategies, schemes, as well as SIP, the Startup Innovation and Intellectual Property Protection Scheme, by which government also funds your registration of patent, application of patent, and other IPs such as design and others, could also be seen as one of the business strategy to go for it, as well as what shall be feasibility would be your question to address. So kindly, let's make this international conference, this session, this law track of this international conference useful by putting forth your ideas, concepts, theories, approaches, so that each one of us could work on that. With this, I would be handing over the mic to the organizers, and thank you all, and I welcome all of you to come here and listen to me patiently. Thank you.
Thank you so much, sir, for your words. So, thank you so much, sir, for your words. You have given the floor for the presentations now. Let's start with the paper presentations. As the first paper presenter, we have Dr. Shruti V. Kamar Dalal, Ameya A. Nayak. Their topic is Splintering the Shackles of Selection Law.
Yes, we already read it. No problem. Can you just
Sonia ma'am.
Then between the personal liberty of the accused and the investigational right of the police. Here I will discuss these things in detail compared with other countries. I have selected 6 keywords around which my topic will revolve. Ordinary bail, interim bail, mandatory bail, anticipatory bail and non-bailable offence, and last default bail. V.R. Krishna Iyer in Gudikanti, Nakshamillu and others versus Public Prosecutor dated 1978, the issue of bail is one of liberty, justice, public safety and burden of the public treasury, all of which insist that a developed jurisprudence of bail is integral to socially sensitized judicial process. Bail was first evolved in England after being influenced by India. This idea was established. The bail provision, especially anticipatory bail, is based on the legal principle of presumption of innocence. That is, every person accused of any offence is considered innocent until proven guilty. This fundamental principle is mentioned in the Universal Declaration of Human Rights under Article 11. In 41st Report 1969, the Law Commission of India made recommendation to the Parliament, which Parliament analysed and incorporated into the Criminal Procedure Code of 1973. The Law Commission, in its 268th report, highlighted the problem with granting bail, where it became the norm for the rich and powerful people to get bail with ease, while others languish in prison. Bail is an important check and balance to ensure that no innocent person is punished without proven guilty. The term bail has been defined under the term bail has not been defined under the Code of Criminal Procedure Code. But the word bailable offence and non-bailable offence has been defined under the code under section 2A of the CRPC. Etymologically, the word bail has been derived from the French word bailer, which means to give or to deliver. Its meaning can be traced from a Latin word bailer also, which means to bear the burden. Our constitutional right to life and personal liberty in Article 29 protects this right. This article gives assurance to each and every person to live with human dignity and personal liberty. In accordance to this article, a person has right to ask for bail if he is arrested by any enforcement law authority. In the case of Motiram and others versus State of MP dated 1978, Honorable Supreme Court observed that there is no definition of bail in the code, although offences are classified as bailable and non-bailable. The court, while reducing the amount of sureties disposed of the application, observed that they could not deny freedom to a person just because he is poor. Bail is the rule and there is the exception. If any person is arrested on the allegation of the commission of a cognizable offence and he is produced before the competent court by the police. Again, court cited that same treatment to merchants and millionaires is illegal. Geographical discrimination is a violation of right to equality. Here I have usually defined 5 types of bail: ordinary bail, interim bail, mandatory bail, default bail and anticipatory bail. One by one I will discuss these kinds of bail. Ordinary bail. Ordinary bail can be granted to a person who has already been arrested and kept in police custody. A person can file an application for regular bail under section 436, 437 and 439 of the code. In a latest judgment, Honorable Supreme Court said that there was in Chandrakant Tambatkar versus State of Maharashtra dated 2022, there was a marriage promise. Members of both families knew this fact. The victim became pregnant. The accused denied getting married and she left the house. After a few months, a baby was born. She left the baby. The accused was arrested. He and his family became ready to get married. Bombay High Court granted conditional bail that if the girl is placed within 1 year, the accused will get married. Bailable offence can be part-wise rule and exception. And rule is that bail is, as a general rule, bailable offences are considered less severe in nature. And its punishment is less than 3 years. The rule is that person shall be released on bail if he furnishes the bail. In case of a bailable offence, there is no provision for anticipatory bail. Justice Markandeya Karju observed that Article 21 must not be denied while not granting of bail. When a person is entitled to bail, it shall amount to wrongful confinement under section 340 of the IPC. An exception was that an indigent person shall be discharged only on the basis of his execution of a bond without sureties for his appearance. He shall be released even without paying bail. Non-bailable offences are serious in nature. It will be discretion of the court to grant bail or not. Section 2A of the CRPC defines non-bailable offences means any other offences than a bailable offence. It is a residuary. In case of a non-bailable offence, the accused cannot claim bail as a matter of right. And the granting authority, an officer in charge of police station has the authority to grant bail in non-bailable offences, but he has also mentioned the reason for granting the bail in case diary and also furnish the bail bond. But if the offence has the maximum punishment of life, imprisonment of death or penalty, the Supreme Court of Canada in Orale GIBS Myers versus Her Majesty the Queen, dated 2019, has held that bail has to be considered on legal parameters. It confers upon adequate discretion of the court to think the enlargement on bail. Cancelling authority, police also furnishes the bail but has not power to cancel the bail. Only magistrate has the power under section 437 clause 5 to cancel the bail, and session court and high court under section 439 2022. Our honorable president Draupadi Murmu has clearly stated that there are many under trial prisoners who have not a bail bond to furnish their bail. There is no need to review the bail system keeping in mind the socio-economic condition of the majority of our population. The provision of bail should be exercised with a focus on reducing the overcrowding of the under trial prisoners. Thank you very much.
Was there any research questions attached to this research?
No, sir.
So you should have taken certain research questions into consideration, like comparing the judgments, just the differences of the opinions अगर है किसी को high court या supreme court के, you could have compared.
Sir, mainly जो है
इसमें जो bail act और जो नए provisions and suggestions की बात करें, उनके questions पर you should have addressed those problems and उनका answer दिया. That would be the conclusion point and that would further the research. Yes, sir. उनको क्वेश्चन बनाया रिसर्च क्वेश्चंस एंड एड्रेस दोस क्वेश्चंस बाय डूइंग योर रिसर्च. थैंक यू.
Thank you.
Thank you, Anuj. The next presenter is Dr. Shruti Dalal and Amyan Nayak. And the paper topic is Splintering the Shackles of Sedition Law. An announcement for all the presenters. The time, we are keeping a time limit of 5 minutes for your presentations, including the questions, and we would like you to please conclude within that timing so that all presenters have an opportunity to present. Thank you so much.
A very good afternoon to everyone. My humble respects to the keynote speaker, the chair of the session coordinator, all the participants who are gathered here in an offline mode or online mode, as well as the organizers of the esteemed institute. I am Dr. Shruti Dalal and my colleague Ms. Amyan Nayak, both assistant professors at Neem Salgakar College of Law. We are presenting the paper on splintering the shackles of sedition law. Next. Now, before we proceed with what is this particular concept of sedition law which exists in India, it's very important why we have chosen this particular topic. We have focused in this area democracy versus dissent, the concept of democracy versus dissent as far as individual or citizen of India is concerned. And what we have tried to specify over here is streamlining the concept of freedom of speech and expression and suggestions for solution therein. Now, coming to this particular concept of sedition law, we find the traces of this law in the United Kingdom. It had its origin in India somewhere in the year 1830. And this particular section was inducted in the draft Indian Penal Code by Thomas Macaulay.
and it has similarity to Section 124A of IPC 1860. Now, the law of sedition specifies about any expression on part of an individual which brings or attempts to bring hatred or incite negativity towards the established authority of the state, that is Government of India, would attract provisions of Section 124A. At the same time, any kind of disaffection which is inclusive of disloyalty and feelings of enmity would also attract the provisions of the section. However, there is an exception to Section 124A which specifies that any expression which amounts to disapproval of governmental measures amounting to disapprobation will not attract the provisions of this section. Now, coming to the next concept of politicizing the law of sedition. We have the very first case that was tried pre-independence period, that was Queen Empress versus Jogendra Chandra Bose, wherein the editor, manager, publisher and the printer of a Bengali magazine at that point of time was charged under Section 124A. However, the court at that point of time distinguished between what is referred to as disaffection and disapprobation and held that there was a criticism that was there in the article that was published in the magazine against the British law that was in existence, where the criticism amounted to only disapproval and there was no disloyalty expressed against the concerned government. That is why the charges were dropped. However, the reason why the sedition law was in existence at that point of time was to subdue political unrest and to crucify the dream of independent India. So we come across trials that were held against the freedom fighters. We have Tilak trial, Mahatma Gandhi trial, where these provision was attracted and the freedom fighters were sent or punished by imputation for life. Subsequently, in Majumdar versus King Emperor's case, it was held by the federal court that the concept of sedition includes public disorder, which is inclusive of anticipated public disorder, and sedition by itself leads to dissent. There is another important point which I want to specify over here about Sardar Vallabhbhai Patel, where he had proposed at that point of time, heading the Fundamental Rights Committee at the Constituent Assembly, that sedition should be carved as an exception to freedom of speech and expression, but this very proposal was rejected. Coming to the next part. Now coming to the constitutional validity of Section 124A of IPC. Subsequent to Ramesh Thapur's case, Brij case, there was an amendment that was brought to the Indian Constitution in the year 1951, where the words interest of and public order were added to the reasonable restriction Article 19 Clause 2, and the amplitude of freedom of speech and expression under Article 19(1)A was increased. Subsequently, the constitutionality of Section 124A of IPC was brought to rest in Kedarnath versus State of Bihar, where it was held that Section 124A is constitutionally valid and it falls within the purview of reasonable restriction under freedom of speech and expression. Shreya Sehwag versus Union of India is one of the most important judgments because it tries to distinguish between what is referred to as advocacy and incitement, and it was held that any expression which leads to incitement or creates kind of hatred would or should only attract the provisions of sedition law. The rest of my presentation will be dealt by my colleague, Ms. Ameya Naik. Thank you.
Thank you, Dr. Shruti. So, at this point of time, we need to focus on certain episodes of sedition that have taken place across the country. So far, we have understood that the sedition law is clearly a debate between democracy and dissent. So, by far, it has become clear that sedition law is nothing but an asphyxiating dictum that suffocates or strangulates dissent, and therefore it defeats the very idea of freedom of speech which is given to us as a fundamental right. Now, coming to a few striking statistics that have been recorded by the National Crime Records Bureau on sedition. We have taken a study of the past 3 years, wherein you will notice that in the year 2018, 70 cases of sedition were filed, that is, FIRs were registered across the country, but there were 0 convictions at the end of the trial. In the year 2019, 93 cases were filed, and there were just 2 convictions. And in the year 2020, 73 cases were filed, and there were 0 convictions. So at this point of time, it becomes clear that there is disproportionality. There is disproportionality between the number of cases that have been filed as against the number of convictions. Next slide, please. So I'll quickly go through, since we are from the state of Goa, another striking statistic with respect to our state is that in the past 7 years, that is from 2014 to 21, just 4 cases of sedition have been filed. Now coming to a few incidents of sedition that have taken place in the country that has got the attention of the public. One is the Farooq Abdullah incident, wherein Farooq Abdullah, the ex-Chief Minister of Jammu and Kashmir and currently an MP of Srinagar, made certain comments with respect to reinstating Article 370 in Jammu and Kashmir, and he made certain references to taking help from China to reinstate Article 370. Here, the apex court dismissed this petition that was filed against him and imposed a cost of ₹50,000 on the petitioners, and held that nothing in the statement made by Abdullah amounted to a seditious act. Also, another FIR was filed against popular journalist Vinod Dua for a YouTube video that he uploaded with respect to communal riots in Delhi. Once again, the apex court quashed this FIR on the grounds of lack of confidence in the merits of the matter by upholding that a journalist has the freedom to criticize the government as per the law of the nation. Now, an important juncture that we need to consider here is this particular petition, which was filed by 2 more journalists, Kishore Khinja and Kanhaiya Lal Shukla, where the very constitutionality of sedition law is currently challenged as of now in the Supreme Court, and subsequently this particular petition was clubbed with 9 more petitions, and the apex court passed an order on 11th of May in the previous year stating that no coercive action or forceful action is to be taken against any person who has been charged with sedition, and they have directed the union to re-examine this law. So as on today, section 124A of the IPC stands in abeyance. Also, it has given directions to the union to re-examine this law, and if at all there is any person who is charged under this act, presently they have the right to apply for bail. Now, as far as UK is concerned, we have taken this law from this country.
Conclude.
Yes, sure, sir. In one statement, if I may say, the country that has given us this law has currently scrapped it. Moving further, so why revisit this law? Revisit the law because it's vague, it's colonial, it's unnecessary, and it does not elaborate on the meaning of hatred and contempt. Further, we suggest 3 things to the executive as well as the judiciary. First is specify the distinction between advocacy and incitement as per the text of 124A. Second, the states and union territory must register FIRs under 124.
I want to say 3 things. First things regarding to the parliament, what is my suggestion to the parliament? There are 3 suggestions to the parliament. My first suggestion to the parliament is that implementation of the law commission's report regarding the 498A of the IPC. Regarding the 498A of the IPC, many reports of the law commission said that section 498A must be put under section 320 subsection 2. It means reports clearly suggest that 498A must be made compoundable offence with the permission of the court. Second suggestions to the parliament is that there are many types of uncertainties. For example, in the Simbaji case, Honorable Supreme Court rejected compromise in the rape case, but in 2009, Honorable Justice Supreme Court clearly allowed compromise with the rape case. Why? Only on the ground that both have got marriages. Such types uncertainties exist in many cases. That's why it is my humble request to the parliament that law must be clearly amended. They must amend section 320 and they should write guidelines, or they should clearly provide that in which circumstances even the non-compoundable cases can be compromised. And last suggestion to the Parliament is that if you go and read section 320, subsection 1, in that category that who can make a compromise. In that, for example, regarding 378, who can make compromise? 379, who can make a compromise? In that column, it has been mentioned that owner of the property can make a compromise. But everyone knows that theft can be committed even by owner of the property. It means theft is a protection from the part of possession, and here owner word must be substituted by the possessors. These three suggestions by the Parliament, and one suggestion regarding the court is that in many cases, Honorable Supreme Court allowed the compromise in the rape case only on the ground that they had got the marriage. What happened? In one situation, for avoiding the punishment, one person got the marriage. He was involved in the gang rape. Under the pressure, he got the marriage. After 1 year, there was delivery of the baby. That person sold that baby. Woman again reached the Supreme Court and said that, Milas, what have been done here? Persons who only for avoiding the punishment got the marriage, and he got the compromise, and later on he sold the baby. It means Supreme Court must always consider post consequences before allowing the compromise to the body like these things. Thanks, my dear friends, and I hope that Honorable Sir will ask some questions.
Yeah, thank you for this such a passionate presentation, sir. Sir, my question would be that was there any other case other than 498 with respect to the non-compoundable and then having been compounded by the Supreme Court?
Yes, sir. For example, there are many categories. For example, there is under section 387, 375, 6. There are many cases, but sir, I have asked only the few cases. For example, in the case of rape, if I want to say, before just in 2019, in the case of Saju Priyar versus State of Kerala, Honorable Supreme Court clearly allowed the compromise in the rape case. Only on the ground that both the parties, the victim and the accused, had bought the marriage and they had started living peacefully. This was the one example in which Honorable Supreme Court allowed compromise in a rape case. If you go to the section 307, abatement to the murder, and most recent judgment regarding the 306, Daksha versus State of Gujarat. This is a historical judgment. In this, Supreme Court clearly discussed if you are going to allow the compromise in non-compoundable cases, what consequences will be done. Regarding 307, in the case of Narendra Singh versus State of Punjab in 2014, Honorable Supreme Court allowed compromise in attempt to murder case, that is in section 307. It means if you go except 498A, Supreme Court allowed compromise in 306, 307, 375, 6 like this. These are the some cases by which we can say that Honorable Supreme Court has allowed compromise even in non-compoundable cases.
So could it not be said that it is a case of the judicial legislation, read with power of judicial review, read with doctrine of severability and read with doctrine of precedent? That is, every case will become the precedent, and as per that it would be the judicial legislation that what would happen in a particular section, for example 498.
Yes.
It could also be said.
So my point is that many times, sometimes Supreme Court laid down the guidelines. In the next time, at time of application of the guidelines, again controversy right. For example, I want to say, in the B.A. Joshi case, guidelines are very clear cut. Hyper-technical interpretation should not be given to the any statutes, and object at time of interpretation of the provisions object of the statute must be considered. What happens? When matter approached to the Supreme Court in 2010 before the division with Justice Markandeya Cartoon. Justice Markandeya Cartoon and Gyan Sudha Mishra, they were very intellectual judges, but even there is the questions. If judges of the Supreme Court, judges of the division bench are raising the ratio, questions on the ratio of earlier judgment, what would be happened regarding the judgments of the high courts? Again here I have cited 7 judgments. In 7 judgments regarding attempt to murder, whatever decision has been given by the high courts, whatever, that decision has been overruled by the Supreme Court. Even the Supreme Court, before delivering the judgment, had applied the earlier judgment, but when matter approached to the Supreme Court said that no, you have not interpreted properly. These are the situations. If the judges of the High Court are not understanding previous ratio, how can a layman and advocate and teachers can understand the ratio? These are my points, sir.
Right. Thank you for your suggestions. Your suggestions would be really helpful for the matter. Thank you.
Thank you, sir. Thank you.
Thank you, sir. The next presenter we have Rituparna Patra. And the topic of the paper is a preventable disaster, smoking.
A very good afternoon to everyone present here. Firstly, I would like to express my gratitude towards the panelists and also towards the organizing committee for organizing this event and giving us an opportunity to present our research work here. The title of our research paper is A Preventable Disaster, Smoking. So, during the COVID-19 pandemic, when everything was going down, people were suffering a lot, there was one thing that did not go down as much, and that was the sale of cigarettes, which is one of the most common ways of consuming tobacco. And India has since then become a huge smoker-rich country, where people with population of around 27 crores are smoking day by day, daily. Use of tobacco leads to major epidemic diseases resulting into social, economic and environmental problems. So we thought that there has to be some sort of legislation governing this aspect of it, and we came across the first anti-tobacco legislation, that was the Cigarettes Act. That was passed in the year 1975, but due to its incompetency and some lacunae, the government has to come up with another act in the year 2003, which was named as the Cigarettes and Other Tobacco Products Act, COTPA, which is still in force. So the purpose of the paper is to understand and analyze why the situation are still in a very worse condition despite of COTPA laws being there, and to assess the implementation process of it, and also to find the reasons why there is ineffective implementation. The paper also tries to make the people aware and understand about their rights and duties and the effect of use of tobacco. The hypothesis that we worked on was first that the implementation process of the COTPA laws are not done properly. So the statutory laws that are there are very strong, are strong enough to deal with the situations right now, but the implementation process that is there is not at par with the statutory laws. The implementation, we are weak in the implementation process, which leads to the second hypothesis, that is, the executive authorities are not putting enough of efforts. So the executive authorities are not under any strict obligations to enforce the laws. That is why the implementation process is being slowed down.
Ma'am, did you take any of the research methods? Did you use any of the research methods to reach out to your faculty hypothesis? Did you test your hypothesis using any of the research methods?
Yes. So we filed an RTI to the Ministry of Health and Family Welfare, to the Tobacco Control Division of it, and also to the State Tobacco Control Division. But and we asked the questions like the number of complaints registered against the smoking law violations. Second was the amount of fines generated by from the violators. Third was the procedure and steps followed by the cell authorities while registering the complaint. And fourth was steps and procedures followed by the cell authorities against the violators. And also the amount of money invested into no smoking advertisements. And we also looked into the data for percentage of number of smokers and percentage of number of non-smokers who have been exposed to smoke through the data provided by GIBS, which has been
which is a global adult tobacco survey, which is conducted by WHO, and we also looked into some of the research publications and we analyzed it. So when we filed an RTI, if we talk about that, the RTI that was filed to the Tobacco Control Division of the Ministry of Health and Family Welfare. The questions that were asked were all replied with that they don't have any data available with them. So and also to the state tobacco control cell that where we sent the RTI also. The RTI was the process that was there when we sent the RTI, the process got delayed and also it was reverted back to us stating that the address is not correct. So the address that is given on the website of on their website, we sent on that address, but it was not correct according to the slip. So in this state, we have a number of legislation governing public smoking in India. Some of them are governing public smoking in indirect manner, and some of them are governing it in a direct manner.
Definition of public place, which is covered under the section 3L, which says that it is covered all the public offices, court building, amusement centers, waiting areas, and all the general public, but not include open space. This is the definition that governed under the Code Act under the section 3L. But if I am talking about the prohibition law, the prohibition section, that is section 4, which says no person shall smoke in any public place, provided that in a hotel having 30 rooms or a restaurant having seating capacity of 30 persons or more in the airport. So it is totally narrowed down the public places in the prohibition law. If we go to the definition of public places, that is 3L, which gives a wider term of public places, but when we go to the prohibition law, it narrowed down. It covered 2% of the public places that is prohibited in a public smoking in public places.
Also, sir, there has been an amendment bill which has been drafted recently in the year 2020. Okay, so the major amendments that were there was regarding section 4, which states that which talks about smoking being prohibited in public places, provided that the hotels have a number of rooms, number of 30 rooms, and the restaurant having a seating capacity of 30 people. But in the amendment bill that has been drafted, the proviso has been eliminated, which made the public places, meaning of public places, much wider in that sense. Also the fines that have been imposed earlier, like right now, which is provided under the Act, is under the Amendment Act has been much higher, which makes the Act much more in a stricter sense. So we think that the amendment bill shall be passed.
And sir, one more thing that we have to look into it, that is the comparison with COVID-19. So there is a very minimal fine, that is 500 rupees for not wearing the mask, that is at an initial stage, and it will go to 5,000 rupees. So sir, if we go to the statistics that is provided by the Times of India and other authorities, it mentioned that in the month of May 2021, 85,000 challans were taken place by the authorities and 15 crore revenue was generated. But when we go through the revenue that generated from the tobacco control programs, or I can say no tobacco, there is no particular data for that. So if we compare to the both COVID-19 situation and smoking law violations, I can recommend that smoking law violations can do effectively at vast places if we implement perfectly, and we can generate a very good amount from these violations. Thank you. Thank you so much, sir.
Please keep on working on those RTI and other data.
Sure.
Thank you, Rituparna and ma'am. Next we have is Advocate Shatrughan Shukla. The topic, sorry, and the title of the paper is Limitation of Law and Trustees.
Respected teachers, honorable friends of legal fraternity, coordinator. Today I will be presenting my research paper on limitations of law and customs issues pertaining to jurisdiction. Recently it has been observed that there is a tussle between the executive and the judiciary. It has came to our attention that one party is alleging that other party is entering into the jurisdiction of the other. Before beginning the presentation, I would like to point out certain definitions which I will be using in the presentation. State. State is the civil government of a country. This phrase will be used repeatedly during the presentation. State includes judiciary. State also includes the executive. State also includes the president and the parliament, which is the legislation of the country. Next is nation. Nation is a large body of people united by the common descent, history, culture or language, inhabiting a particular country or territory. Nation is pre-existing. States come and go. Constitution. Constitution is an instrument being special legal sanctity which sets out the framework of the principal functions of the organs of the government of a state and declares the principle governing the operating. It's just like an operating process, operating system of a computer. As in a computer, certain guidelines are set that okay, I am going to do this, we are going to do this. One part does something and another part does something else. Now the second thing is, what we consider a constitution is a social contract. It is a contract between nation and the people, nation and the state. We have delegated certain of our responsibilities to the state, such as management of the resources, how to deal with the enemy, external affairs, telecommunications, etc. Certain things we have kept us indulged in and have not shared, which will be discussed later on. However, now the question arises, what part we have shared and what not? This is the main funda behind the jurisdiction. I must say this is August gathering, but I'm not getting enough attention while I'm speaking. So may I have your attention before I'm speaking? I'm sorry if I'm not being too interesting before presenting my idea to you. The Constitution, which has been established in 1947 by the Constituent Assembly of India, was a written contract between its people and the machinery it is going to engage. Because for 1,000 years, we have been imposed with a machinery which we did not choose. Some people have entered into the territory of the people who were living for thousands of years, and then they have overtaken it. Foreign ideas of religion, foreign ideas of social being, foreign ideas of how to rule ourselves, foreign ideas of law, etc. They have been imposed on us. So what we have decided in 1947 that okay, we will have a legal sovereignty first. And with that, we have introduced ourselves with the constitution. In that constitution, we have taken the idea of Mr. Montesquieu. We have a separation of judiciary, but not entirely separate. All the three parts have a bearing over each other. That is known as checks and balances. The theory of checks and balances say that if a system, if a limb of the state goes wrong or goes rogue, the other limb will control it. If suppose President exercises its power and takes the charge of making a law and decided that he is only going to decide upon the cabinet, our constitution comes into force. It says, no, you cannot do that. If Parliament decides that it's going to amend the constitution as it wishes and crush our fundamental rights, constitution comes to the force and says, no, you cannot do that. Judiciary, if it decides to go rogue and says, we are not going to abide by the law and decide as we wish, it's not going to do that. It is not going to happen. So who's going to stop each other? Nobody can, except for the other two limbs. So if 1/3 part of the state machinery goes rogue, 2/3 part will be acting to correct that. What is the law? Article 367. Article 367. Yes. Back, a little back. After this. Yes. Article 367. I am speaking on the law, so it is pertinent that I must say what law is. The law is any reference in this constitution to acts or laws or made by parliament or to acts or laws or made by the legislature of a state shall be construed as including a reference to an ordinance made by the president or to an ordinance made by a governor as the case may be. So law can be made by either a legislature or the representative of the people or the people themselves, not by a judicial person who is appointed on the seat of a judge or a magistrate. They cannot make the law. Constitution declares it in Article 367. Now, I must differentiate between the law and the customs here.
Please put on your video so that it is you are visible to us also. So I think there is some connectivity issue. Surya KS is here. Lakshmi S.
Yes, ma'am. Lakshmi here.
Right. Lakshmi, you can start.
Am I audible? Please, can you answer me?
Yes, Sanju, you are audible. Okay, so we'll start with Sanju and next we'll take up is and yeah.
Respected keynote speaker, chairperson, and all my other delegates, I am Sanju, research scholar, Department of Law, Finishing University, Toronto. And I am going to present my paper on the legalization of euthanasia in India. And my co-author is Dr. Pritita Nankar, Assistant Professor, Legal and International Business School, IIT Delhi. Now, I want to start with my paper that every nation should have a right to life. The right to life is guaranteed by Article 21 of the Indian Constitution and Article 3 of the Universal Declaration of Human Rights killing or permitting the death of hopelessly sick or injured individuals, such as persons or domestic animals, in relatively painless way for reason for this. According to the House of Lords Select Committee on Medical Ethics, the definition of euthanasia is deliberate interference undertaken with the express intention of ending a life to relieve intractable pains and agonies. There are different kinds of euthanasia, and it is categorized on the basis of informed consent. First one is voluntary euthanasia. Euthanasia with patient's consent is referred as voluntary euthanasia, and this includes the cases where a person requests assistance in dying, refuses intensive medical care, and requests to terminate medical treatment or end their life, requests to turn off life support equipment, and etc. Second one is non-voluntary euthanasia. It refers to the practice of ending a patient's life when that person is incapable of making a decision, such as when they are comatose, mentally incapable, or unable to communicate their wishes, as in case of baby born with severe congenital deformities. Third one is involuntary euthanasia. This is commonly referred as murder, and in this, when someone is put to death without the will. Now, the second category, the basis of categorization of euthanasia is regarding its winner. First one is active euthanasia. That it is. Yes, sir.
Mr. Can we know about your research questions, methodology, and then conclusion? Can you sort of?
Sir, the research of the question is what is the role of judiciary in legalization of euthanasia?
So, using what methodology, which conclusion could you reach?
Okay, so that's the question. The judiciary plays a very important role in the legalization of euthanasia, and judiciary finally recognized the right to die as a fundamental component of right to life through several rulings like Yanko, case, Aruna Chandra case, and common court registered case. I would like to present some suggestions for the process of euthanasia in India. First one is, it is urgently necessary for the legislature to establish a new law on euthanasia, since the country's legal right to die needs to have a solid foundation. Second one is, appropriate guidelines must be created for the process of administrative euthanasia. The Supreme Court guidelines are not specific enough to guarantee that exercising of this right won't have unintended negative consequences for anyone who is choosing between life and death. Third one is the doctor's solitary judgment about the administration of euthanasia is risky, since there is a probability that he could abuse the authority granted and endanger someone's life. The court is always carefully scrutinize doctor's decision to ensure that no negligence was attributable to them. We should be, the right to life is a complex matter. We should leave this matter in the hands of judiciary to serve the interest of the society. Making it law is important, but we Indians also need maturity to manage such delicate topic by carefully weighing its advantages and mistakes.
This way, did you do any of the comparative study of the different legal systems and guidelines provided by the judiciary or other organizations?
Sir, I am not able to
the comparative aspect of your research. Did you do the comparative study?
Sir, I don't include the comparative aspect in this. I only research on the basis of judiciary.
So while suggesting your guideline, try to incorporate certain comparisons of different legal systems, their judicial guidelines, and the guidelines set by legislations or other guidelines. Okay, thank you.
Sir, I will try to implement it.
Thank you.
Thank you, sir.
Thank you.
Sanju.
Yes, ma'am.
Thank you so much.
Okay.
Is Dilpreet here? Lakshmi?
Yes, ma'am.
Yes, Lakshmi, you can start presenting. The topic of Lakshmi's paper is Gender Equality in the Corporate Managerial Position, a study in the light of Chanda Kochar case. Chanda Kochar case, sorry.
Good afternoon to everyone. My topic is gender equality in corporate managerial position and studies like Chanda Kochar case. Topic to start with the topic at the beginning of gender balance. For OECD guidelines, gender balance is equitable, distribution of lives, opportunities, resources between women and men, and an equal representation of women and men. And gender disparity, the gender disparity occurs when there are differences in women's and men's access to resources, talents, and management, which usually favor women. Here, the study focuses on the gender equality standards in corporate managerial position. To that point, I have some research studies which have been conducted by many organizations. The data has revealed the fact that women are more likely to have a transformational leadership style. In a research conducted by Harvard Business Review, the majority of leaders in corporate organizations are men, and also the management and the next level down to the managerial force. But the surprising fact is that all those who are in those positions have observed that female leaders excel at their position than men. Female gender excel at that. Therefore, in fact, they excel at their position but still not the top. And why is so? The answer is blatant discrimination. Now, moving on to the legal professions, in respect of these people who says to make special consideration to women to be in the board of directors. The Companies Act 2030, Section 149 provides that the prescribed class of companies shall have at least one women director on its board. And Rule 3 of the Company's Appointment and Qualifications Directors Rules 2014, which gives the women director on the board, which provides that every listed company and every public company has a paid-up share capital of 100 crore or more, and turnover of 300 crore or more shall have at least one women director on the board. And moving on to the Chanda Kochar case, it is struggling learning for every woman to be in the top managerial position. When they reach, they are struggling to deal with family and social pressure. One such example is Chanda Kochar case. The case involved this 3,250 crore in loan given by the ICICI to the Video Control. Chanda Kochar was part of the sanctioning as well as recommending committee in the proposals made by the Video Control. It was in violation of banking regulations and ICICI bank policies. Later, the company granted a loan of 64 crore to power renewables unit Video Kochar. The Movies Chanda Kochar success at 50% stake. It was actually a quid pro quo deal.
They have any contradictory or differential opinions.
I didn't tell the comparative studies. I just limited.
Why aligning these provisions and laws and policies of India, could you find out that for the purpose of the environmental justice, was there any kind of difference of the opinion between the two policies, between the two judgments, between the two judges of one bench, etc.?
Sir, scope of my paper is not even the judgments. I have narrowed down the scope of my paper. I have just evaluated the policies and the legislation of the laws. I have not gone into the judgment passed by.
Not at all. So So then let's discuss about the questions which you framed for analyzing the policies and what
Yes,
are the conclusions behind it.
These are my research questions. First research question is, how does the concept of environmental justice shape environmental policy and regulatory frameworks? And the second question is, what are the challenges in the way of effective implementation of environmental policies and regulations? So, if we discuss the key principles of environmental justice, that is the fair distribution. Second is right to participate, and third one is recognition of the natural world, and the last one is right to a healthy and sustainable environment. And if we analyze these principles in the context of Indian regulatory and policy frameworks, there have been a lot of changes since the origin of this principle in 1982. If we look at the policy making, there have been development of specific policies and regulations that aim to address environmental justice concerns. The government has made from time to time different policies, whether it is related to the national parks or related to any development project. And other than that, there have been incorporation of environmental justice considerations into the policy and decision making processes themselves. And then third one is use of legal and regulatory tools to address environmental justice concerns. So the third one is the most important aspect. As we can see in the regulatory framework, if we come to the regulatory framework, the first aspect is the development of specific policies and regulations that aim to address environmental justice, such as National Action Plan on Climate Change and National Green Tribunal. So, this specific aspect of National Green Tribunal can be connected with the environmental justice, because one of the aspects of environmental justice is to provide access to justice to the person who have been affected by the certain developmental projects or some other infrastructural project. So NGT provide that access. That is the procedural aspects of environmental justice. Second one is addressing environmental justice concerns to legal.
Could you please summarize these provisions of your conclusion?
Yes, sir. So basically, these are the legal provisions, and challenges are limited enforcement and compliance, lack of participation and consultation, deficiency of resources and capacity, and lack of awareness and enthusiasm among the citizens to adopt substantiate living. Then I have these three suggestions to improve the compliance of the environmental justice. First one is to prioritize and invest in research and data collection efforts that shed light on the disproportionate impacts of environmental harms on marginalized communities in the country. Second suggestion is that bring marginalized population into the policy making process in India and give them the tools and assistance they require to effectively participate in the EIA process. And last suggestion is to identify places where these populations may be disproportionately affected by proposed policies or projects, affecting by effectively implementing techniques such as screening and monitoring.
Thank you, sir. Very interesting information.
So, I have a question.
Yes, sir.
Dr. Vikram, sir, regarding your suggestions, you have used the phrase marginalized communities in the country.
Yes, sir.
Sir, however, the implications of environmental degradation will come to all communities.
Yes, sir. It will come to the all the communities, but the origin of and concept of environmental justice is like if you look at the origin in US, it was there was a project which was going on, and that project was in the area of black community. And if we consider tribal areas can be considered as a marginalized community, because most of the developmental projects such as mining and then related to the highway and other construction infrastructure projects took place in those areas where the tribal population is. So it affects them as compared
marginalized communities does not include only the tribal communities. The phrase marginalized can be read as the minorities as well, and the people living in the urban areas as well.
I have not defined it in my presentation, but in itself, if I can define the scope of my papers when I am using the word marginalized communities, I am specifically referring to the communities who are living in forest areas or areas where mining is taking place. And during these kind of projects, when the government is initiating these projects, there is no such kind of consultation with these communities, and most of the environmental effects are borne by these communities.
So we can include those communities as well. That's what you're saying.
Sir, it depends where that project is taking place. I'm not saying that when I'm using the word, I define marginalized community in my paper. My definition of marginalized community is tribal people who area where these projects are taking place and whose voice is not being heard in the mainstream discourse.
Thank you.
Vikram, is Harsh present?
Yes, ma'am.
Yes, you can start your presentation, Harsh.
Yes, ma'am. This minute.
Please start your presentation.
This is Srivastava. I'm from Georgia College. I'm in third year of my BA program. Today, my discussion topic is basically insolvency and bankruptcy code. In that, I have basically discussed about the standing position of insolvency and bankruptcy code. The insolvency and bankruptcy code has been introduced this is 6 years, and of course we have the related so it is necessary to analyze what is the standing position of insolvency and bankruptcy following current time. So starting with the introduction part, I would like to say that like for a developing country, a stable economy is very necessary for that industries, companies are some of the pillars for a healthy economic country. And when these pillars give loans, and when that loans comes into a bad loan, then that will create then that bad loans act as a certain obstacle in the path of a smooth flow of the economy in the society. So for that purpose, the insolvency and bankruptcy code was introduced in the state. Although so not like that before I would say there was entire legislations before insolvency and bankruptcy. There were many legislations and acts before regulating the market in terms of economy and for particular I can say about insolvent companies. But with a particular reason, the insolvency and bankruptcy code was introduced. And basically, IBC was introduced with 3 objectives. The first objective was resolution. The second objective was maximizing the value of assets of the corporate sector. And the third objective was entrepreneurship, capability of credits and balancing the interest. The main aim of this code was to affected by the business cycle, or I can say we are looking to fake debt. Furthermore, I would say.
Mr. Harsh,
Yes, sir.
Mr. Harsh, what questions, concept, or issues are you addressing in your paper? What is the objective of your paper, and then how did you address them? The research topic.
My research question in simple word is to analyze what is the standing position of insolvency bankers after the introduction like has been fixed. So I have analyzed in my paper the current position, the standing position of insolvency and bankers.
Only the judicial data, or you also have analyzed it depending on certain statistical data which you collected?
I have incorporated both the things, also the statistical part and also the judicial pronouncement and the banks the IBC in this stage.
Where did you collect your statistical data?
If I talk about the statistical data of India, now we have 14 NCIs. When the IBC was introduced, there were
Cases, pendency cases.
I have included many like there are many uses for transparent IBC to judicial pronouncement. The first big case is Swiss Legal Private Limited and another one is Union of India. This case, in my opinion, is the biggest landmark judgment in IBC because the IBC was introduced to save the corporate debtors. Before IBC and before this judgment, the whole concept was to save the corporate creditors. But after this whole court went to the Supreme Court and Supreme Court gave a verdict, basically the justice would like to state a statement by Honorable Justice Colin and the statement of the defaulter's paradigm is lost. In this case, the economic cycle position has been maintained. So this one line sum up the entire vision of this judgment, and this particular judgment, the concept of the
So how this case and the other important cases which you are addressing in your paper are impacting IBC? So what is the conclusion, what is the analytical conclusion could you find out by analyzing all these cases?
If I talk about this particular case, the Supreme Court gave this particular case that the core objective of IBC is to ensure the revival and continuation of corporate debtor. Because this judgment, the emphasis was on the revival of corporate debtor because debtor was only for the who gives loan. So the concept was changed after this case. After this case, the emphasis was to revival and continuation of the corporate debtor. Also, the main objective of the IBC, as per Honorable Justice was to preserve the corporate debtor while making sure that there should be actual recovery of all the creditors. So,
Mr. Harsh, could you please reach to the conclusion? Could you please conclude that?
yeah, okay. To organize the current legal policy and provision in order to slow the reports and what is created by the legislation prior to IBC, in particular to majority percentage to have the provisions in IBC and the majority percentage to oppose the legislation plan by the committee of the Minister and reduced to 66% from the 75% to 2018 amendment. But there is no transparency in the concept. So basically, like any other law, IBC also needs to improve some data. The current and undoubtedly, there is more achieved to stand up the benchmark and set as a developed country. Despite all the burdens and sort of IBC is the angular of economics, trying to reconstruct itself with the modern trade. We are trying to use the businesses and this is the evidence.
So, I'm very sorry, but I would like you to conclude now. Because we are already making our program a lot.
This was the conclusion and I would like to conclude my presentation and I would like to thank all the
are you here?
Yes, ma'am, I'm here.
Yes, you can start the presentation.
Ma'am, can you see my PPT? Am I visible?
Yes, it is. You may start.
Am I audible, ma'am?
Yes. Swati, you may start. The PPT is also visible to us.
Okay. Respected key speakers and chairperson, my name is Ashwati Kumar. I'm a research scholar at Hindustan Institute of Technology and Science, Chennai, and my topic is corporate governance and insider trading in the contemporary era. So, moving to study corporate governance, it is a system by which a company that is acted and controlled. It encompasses the entire mechanism of function of a company and attempts to put in place a system of checks and balance between the shareholders, directors, employees, and the management. So some of the key principles of corporate governance are accountability, responsibility, and transparency. Now, looking into the benefits of corporate governance, we can say that it ensures corporate success and economic growth, then minimize wastage or corruption, risk and mismanagement, then it also maintains investors' confidence and it promotes long-term financial viability, opportunity, as well as the returns. And it also helps in facilitating and raising the capital of the capital to the particular companies. Now, looking into the topic of insider trading, it is a concept which has considered and it is considered to be something which has been raised in the recent case, in the recent years. So, it is an act which is engaged in buying and selling of the securities by the person who is having unpublished.
Swati, just a minute. Yes,
Could you please jump on to your research problem and then hit result?
Yeah, sure, sir. So the challenge which I would like to say is one thing is that security is the principle of privacy and efficiency. Second one is that it is appropriate with offering valuable information. And thirdly, the range of fiduciary position of trust and confidence arises. And here the potential conflict of interest is that the best interest of the company will be pushed aside in favor of the self-interest of the insider. And after all, it corrects the level winning feeling. So I just read we have 2000 between India as well as UK. Sorry, India as well as US. Now I am going to my recommendation which I would like to suggest is that in India we are having only one that is Security Exchange Board of India criteria to with insider trading as well as we are having only the regulation. So what I want to recommend is that like service mechanism is very less in India compared to other countries like US and all because they are having wiretapping mechanism and new technological development has been taken into consideration in order to take the people to find out people who are indebted in such insider practices. And coming to other recommendations which I would like to say is about the resources and manpower. Here we can according to Delhi's Act, we know that according to March 31st, 2022, by looking into the total staff of or the strength of the SEBI, we can see that there are only 980 officers are there. So these officers they themselves have the responsibility to detect offences and to take their action. So many more infrastructure as well as resources has to be incorporated. And coming to the third point is that the functioning of the regulatory authority has been lessened in order to meet the complex issue of insider trading. As I have already told, the SEBI is the SEBI, that is Security Exchange Board of India, is the only regulatory mechanism which is exclusively dealing with insider trading. So they are vested with the three powers, that is legislative, executive, and judiciary power. So here, like the method of legislative, they are having, they have to formulate and regulate.
Swati, I'm sorry I'm interrupting you, but please conclude. We are running short of time.
So I would like to conclude
Thank you so much. Is Sarita Ranga here?
Yes, sir.
Yeah, please, Sarita, you may start presenting.
Ma'am, give me a minute.
After Sarita, is Shikha there?
Okay, now is the PPT visible?
Yes, ma'am, it is.
Okay, so ma'am, my topic is globalization, in which I'm studying the impact of globalization on India with challenges and perspectives. So, in this, I'm just the paper is very hard to read, but there is so much time left. So, as I have put the paper, I have defined the globalization first. The objective of the paper are to understand the impact of globalization and evaluate the government policies that is implementing the government these global developments and innovation. The research questions are the changes and challenges that India faces and the role of state. It is the role of state practices in development. The methodology is purely considered. These are the changes after globalization that we know that globalization has been integrated theater. Medical facilities have due to technology change. These things are happening that we are having to online content and all. Due to technological innovation and greater dependency on trade, we have established various global social networks and those state monopolies have come. Because of the technological innovation, because in earlier times, most things were good by the government of the monopoly and there was state monopoly, but now this is government. The issue is globalization.
So, Ms. Sarita, what is the outcome of your doctoral study? What is the outcome? What do you have hypothesis false or good?
The outcome basically has clarified the role of the state, especially in India, in addressing the needs, the present needs. Globalization has removed the various barriers for India now we have to decide whether we want to take benefits of globalization or we want to not take benefits, but we want to do our resources by accepting the global. And this is the conclusion. Wherein I have started the beauty of the state making global international development like the India, we need to make the rules that not other states do so hard development. Thank you.
Alright, with this we come to the end of the session. Thank you so much, all the presenters, all the delegates who are with us. I would like to thank our keynote speaker, Dr. Anna Elsa Mondria Pentado. The session chair for today, Shri Abhinav K. Mishra, for sparing their time, their precious time with us and helping us in the judgment for the best paper. I thank everyone, all the participants, for participating in our international conference, presenting their papers beautifully, and thank you all for being here. I would request Vinay sir to present a memento to our keynote speaker, Abhinav K. Mishra, as a token of respect and gratitude. Thank you, sir. Thank you all for being here, and I request all to remain with us for the valedictory session where the results for the best paper will be declared. Thank you once again. Thank you all.
I would like to welcome and introduce Dr. Sunita Vishnoy, Associate Professor, GIBS Institute of Management, Faridabad. She has done Doctorate of Philosophy in the year 2009 from Guru Jambeshwar University of Science and Technology, Hisar, Haryana, MPhil from NGO Rohtak, Haryana, Masters in Economics from KUK, and MPhil. She has also done NPTEL certification courses. She is a member of Board of Studies in NGO Rohtak, Haryana, member of Department Research Committee NGO Rohtak, Chairman Club Committee of Karate again NGO Rohtak, and member Club Committee of Kickboxing NGO Rohtak. Her areas of specialization are finance, economics, and research, along with that human values. She published 40 research articles independently and jointly as a research supervisor in national and international referred journals, published 14 chapters in edited books and conferences proceedings during ISBN numbers. Now I request Dr. Sunita Vishnoy to enlighten us with her precious word. Please, ma'am.
Thank you, Dr. Kumar. Myself, as introduced, we all are at same platform. Okay. The young researcher will be at this stage after some time. We just born 20 to 25 years before you. This is the only difference I think we have. And thank you so much. First of all, I congratulate Geeta Ratan International Business School to organize such an event. And it is your 13th international conference. And first of all, I would like to thank Chairman Sir, Shri Anand Jindalji, Vice Chairman Sir, Shri Anirudh Jindalji, Dean Academics, Ms. Prachi Jindalji, Conference Convener, Dr. Sheetal Chadha, and my friend, your Institute's Professor, Dr. Urvesh Chaudhary. I would like to thank you all to invite me for this occasion. And congratulations to the whole team to conduct such a nice international conference. And these kind of events are very important for the academicians as well as the students as well as the industry practitioners. You know, we as academicians prepare product for industries. And industry are looking forward to institutes to prepare such kind of human resources that they can grow and they can run their business in a better way. So these kind of, and you at Geeta Ratan Institute, I must congratulate you. You are the lucky faculty members that you are continuing your 13th international conference. Most of the institutes are not organizing these type of conferences. You know, your institute is providing you a platform where you can network with different institutes, students, and all over the world. And I was also looking that there are some international participants as well as the chairpersons also. So it's a great opportunity to you people to learn. And as a session chair, my message to the young researcher is just that as you must have heard an dialogue from I think Shah Rukh Khan that films chalti hai entertainment, entertainment, entertainment. And academics and research, study, and learn. These are the two important terminologies or the words which move you to the next level of your success or your, you can say, the achievement of some good milestones in your life. And as related to your conference theme, that aiming change for sustainability. COVID pandemic, now it's obsessed word, everywhere we look this word like COVID pandemic. COVID pandemic not only changed business style. It has also changed the way of thinking. It has also changed the way of consumption. It has also changed the way of teaching. It has also changed the technology. Everything is upside down after this COVID pandemic. And these type of international or national conferences give us the platform to reflect our views, to reflect our observations. So, it's my advice to students as well as to the faculty that you must join these types of conferences. Okay, and we were discussing before this session that this online is a good thing. It has reduced cost from the academic institutes, but the effectiveness and efficiency is still challengeable in online platforms. So I must request all the online participants that kindly, it's a good opportunity to you people that it's very convenient, very cost effective, but we must learn and we must take seriously these types of conferences and seminars. And lastly, I want to congratulate the conference convener, the GIBS organization, teachers, all the participants, presenters, and one line I just want to add that there are some best paper presented award, but don't think that your paper was not good or you are lacking somewhere. Okay, you are the best, but the award is going to the best. Okay, this is the only difference. And I congratulate the best paper presenters. Okay, and we have, it's very difficult to reject someone. It's easy to accept, but it's very difficult to reject someone. That yes, this is the best. So it's also a difficult situation for we people, and I think all the chairpersons are thinking in the same way. That it's not easy to select the best one because you all are good. So I congratulate Gita International Institute and the teachers and each and every person who is directly or indirectly connected to this two-day international workshop. And it's a great success for you people. I congratulate you all. Thank you so much.
Thank you so much, ma'am, for your insightful words. The large number of participants came in the international conference titled Global Information and Business Strategies in various tracks, namely marketing, finance, HRM, law, economics and IT, and general management. Now it's time to announce the results. I would like to call upon Dr. Sunita Bishnoi ma'am and Dr. Urvesh Chaudhary ma'am, Dr. Sheetal Chadha ma'am, and Professor Dr. Vinay Vetri sir, Dr. Neil C ma'am, and Dr. Ramanarayan sir.
सेशन जो है ना सेशन की टाइप में बैठ करें अभी आप कौन सा सेशन अनाउंस कर रहे हैं
The name of the participants.
ओके फॉर विच सेशन
For all these
कौन सा सेशन लेके जा रहे थे मार्केटिंग ओके सो मार्केटिंग ट्राई पर्सन अंजलि मैम
She's in examination. She's there.
Ajay.
So I'm announcing the names of the participants in the marketing track. First is Ms. Marty Zirdo and Dr. Shankar Thapa. Please come on the dais. Dr. Richard Abbas, Dr. Mamta Rani, and Ms. Ankita Sharma.
Shankar Thapa.
साइड पे करो इसको। कोई बात नहीं, साइड पे डिस्टर्ब है।
Next presenter is Ms. Ankita Sharma, Dr. Mamta Rani and Dr. Richard Abbas. Please have a little round of applause for all.
अभी सर्टिफिकेट ऑफ मेरिट किया हाँ अभी वो दे दो क्या एक बार आपने सर्टिफिकेट ऑफ मेरिट बाद में अनाउंस कर
Yes,
So everybody be here. We would be announcing the best paper award little later.
That is
just be here.
Next presenter is Ms. Soni Rai, Ms. Nisha and Saurabh Kumari.
Online.
Dr. Suruchi Tripathi.
She was also online.
Now, I'm coming to finance track. Amit Kumar. Migrant Bhavna, Dr. Chandra Thapa.
सीधा वाला नहीं।
Mr. Samir Kathuria and Dr. S.K. Gupta, Ruchi Kalia, Dr. Shani Srivastava, Dr. Ruhi Mittal,
Please come. Please come.
Please clap. Next is Ms. Sonia Peter, Dr. Dipti Ranjan Mohapatra, R. Sri Nivasan.
Next comes for the
Now we are answering for HR and track. Manisha Khanna, Dr. Niti Rana, Dr. Vikas Kumar, Dr. Shubham Agarwal.
Next. HR turn. आइए मैम आप
Mr. Shiv Prasad, Mudhukar Chette,
come please join.
Sunila Banerjee, Dr. Mustaq Ahmed. Please clap. Jyoti Rathore, Tamanna Agarwal, Dr. Sandeep Arya, Dr. Kamini Bhasin, Ritu Singh, Simranjeet Kaur Bagga. Now I would like to call upon Mr. Abhinav Kumar Mishra. Please come on the line.
Law.
Next is the law track. Dr. Shruti E. Kumar Dalal, Amena A. Nair. Please have a few rounds of applause for them. Anup Singh.
Thank you, Amya, for coming all the way from Goa.
Dr. Dr. Krishna Murari Yadav, Rituparna Patra Mayam Jain, Shatrunjay Shukla.
सर्टिफिकेट्स
चला रहा है डॉक्यूमेंट फोटो से देख रहे हैं ना वहाँ पे क्या मैं ऑनलाइन कर रहा हूँ यहाँ भी देख रहा हूँ.
Now announcing names for the IB and the Economic Track.
IB and Economics track session.
Dr. Mohammed Fahim.
एक मिनट.
Session content.
Are we on?
Dr. Mohammed Fahim.
कोई नहीं ये भी फोटो खत्म बैठे ले निकाल कर रखो 10 मिनट चली जाएगा.
Jyoti Sankar Das, Preeti Mishra and Dr. Hezbeen Banu, Snigdha Mehta and Shriyas Jain. Please have a huge round of applause for her.
ले आओ ना बैठे लेके आओ.
Snigdha Mehta and Shriyas Jain. Please clap. Mohammed Afam Akhtar, Serajan Haq and Mohammed Rashid Faruqi. Miss Elvina Negulier Dr. Shankar Thapa. Now I'm announcing for the General Management Track.
Please
ये खोलेगा
General Management
For General Management Track, it is Dr. Parul Agarwal, Ms. Jyoti, Dr. Deepti, Dr. Mamta Chawla, Dr. Amit Verma, Ms. Vaishnavi, Ms. Anika Gandhi, Dr. Sonia Rajoria, Dr. Sonia Rajoria. Please have a huge round of applause for her. Shalini Sharma, Anil Kumar, Dr. Tanmay Pant, Dr. Shekhar Singh, Mr. Dipanshu Agarwal, Dr. Smita Mishra, Dr. Tanvi Gupta, Suraj Sharma, Dr. Tanvi Gupta, Ms. Pratika Singh, Dr. Mamta Rani.
आइए आप पूजा माँ
तीनों इकट्ठे हैं एक इसके
इधर तो वो जल जाएगा
नहीं बनाया सिर्फ ऑफलाइन वालों का बना
Mr. Prakash Sharma, Vikas Kumar, Dr. Shadu Tyagi.
मेरा है आपका है आपका है देना इसका
In finance track, Dr. Ruchi Kalia.
Yes, sir. I think there is no certificate required already, doctor.
होने वाला
नाम है
Okay, thank you. We can now.
Now I'm announcing names of the best presenter for various tracks. I'm going to start with the marketing track. The best presenter award goes to Miss Marti Zirdo and Dr. Shankar Thapa. He'll be getting a certificate and along with that a cash prize. The best presenter for the finance track goes to Ms. Sonia Peter from Amity University, Dr. Vicky Ranjan Mohapatra, and R.T. Vasu. Please come and give a round of applause for her. The best presenter from the HRM track goes to Manisha Khanna and Dr. Neeti Rana. For the law track, the best presenter goes to Dr. Shruti V. Kamat Dalal and Ameya A. Nair. Please have a few round of applause for them. For international business and economics track, the best paper presenter award goes to Dr. Mohammed Fahim. For general management track, The Best Presenter Award goes to Dr. Tanvi Gupta, Ms. Pratibha Singh and Dr. Mamta Rani.
एक एप्रिसिएशन अवार्ड नाम मार्केटिंग का एप्रिसिएशन अवार्ड अंकिता शर्मा This is a special appreciation award other than the best paper award in the session. We are giving it to Ankita Sharma.
I request all the dignitaries to please take the seat. Thank you so much, sir. Thank you so much, ma'am. Now I.
So, dear all fellow presenters, I hope you all had a wonderful time. We are pleased and thankful for the contribution to the by your research work in the vast area of interest, from law to management and administrations. We have quite a good number of papers presented in offline as well as online. In this 30th International Conference of Global Information and Business Strategy, we are highly thankful to our Chairman, Sir, and Vice Chairman, Sir, for conducting a smooth flow of this international conference. We are thankful to all my colleagues, faculty members, for working day and night for success of this conference. A big hand of applause to all the faculty members. We are also obliged towards our eminent resource person, Dr. Smita Bishnovi, for gracing the event and for sharing valuable feedback with us. Thank you very much. I hope in future also will get support for organizing this international conference from all of you in the way of providing your research work and presenting your research work in offline mode. Thank you very much.
Are you beautiful?
राजेश आप भी आइए।
Please come.
आप इधर हो जाओ ना, आ जाओ। Thank you.